Please do.
EMC is being held by way of video conference with Justice Sir Jeremy Cooke. The judge hearing this application is appearing from the UK. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on Justice Sir Jeremy Cooke's instructions. We are here for a case management conference in the matter of CFI 013-2019 before Justice Sir Jeremy Cooke. The claimant is represented by King Spalding. Lead counsel is Tom Springe. The defendants are represented by Gibson Dunn and Crutcher LLP. Lead counsel is Tom Montague Smith, QC.
Very good. All right, thank you very much. Now, I've read the papers, so it's really a question in what order you want to deal with the various matters. As I understand it, you've agreed the directions from start to finish other than trial days. We need to discuss how long you need for that in the light of the number of witnesses you're talking about. And then, of course, we've got to deal with the question of further and better particulars and the costs of the previous Court of Appeal and first instance hearing. Do you want to tell me which order you want to take these things in, Mr. Montague Smith?
Well, that's the order I had in mind, Your Honour. I'm very happy if Mr. Sprange is happy with that as well.
No, Malone,
Are you happy with that?
Yes, I think that makes sense. And to be frank with you, in terms of the directions, the only real issue between us seems to be the date after which the trial ought to be listed. And on that, if I may say, I think the parties' positions are very clear in the written submissions.
You're a month apart, aren't you, with Christmas in between?
Exactly. So I certainly won't be burdening you with much on that. I mean, I think we're very much in the court hands.
The key issue, Mr. Sprange, is how long is the trial going to last? And
Quite.
I'm told I'm going to be assigned to do it. So it's a question then of a date that works for me and for the court and for both of you.
Quite. And as far as we're concerned, it is an 8 to 10 day estimate, given the number of witnesses. And when I say given the number of witnesses, I'm taking it from both parties' case information sheets.
Yes. Well, exactly so. I mean, I looked at that, and it seemed to me we've got 2 fact witnesses for the claimants, 6 fact witnesses for the defendants, and 2 experts each. I mean, it's always a bit of a guess as to what that's going to take, and you have a much better idea than I do. But 8 fact witnesses and 4 experts looks to me like 8 days before you even start closing speeches, opening and closings. I think you're probably looking at 12 days to be on the safe side.
Always happy for extra time.
Sorry?
Always happy to have a little extra time.
Well, indeed. I mean, if we have extra time, then you can have a time out to write your closing speeches or whatever. But on the face of it, it's a mistake, particularly when booking my diary ahead of a foreign judge, so to speak, who can't just sit on the extra days in DISC necessarily. It's better to have more time than less, otherwise you run into the business of adjourning with the case not finished. Do you have any views, Mr. Montague Smith, about length?
I think it's better to err on the side of caution.
Yeah.
I mean, I think we'd seen the claimant's estimate was about a week to begin with, so we'd said, well, it's clearly going to be more than that. I think I'd said, you know, this is at least a 2-week trial, but I can see that it's better to build in a bit of extra time. And as you say, Your Honour, I always find it helpful, and I hope you do, to have some oral closings, and those can often be better presented if there's a little gap at the end of the trial anyway. There may not be time for that, but even if there is, it seems to me it'll be well used. I'd be inclined to agree with Your Honour's instinct on this and make provision for 12 days.
And I always take the view that, if you, broadly speaking, a fact witness of the ordinary kind is a half day's worth. Just as a rough stat, some will go a full day, and in this case, there'll be some who are more important than the others, and 1 or 2 will go short. But as I say, if you work on that basis, you've got 4 to 5 days of fact witnesses, you've got 3 to 4 days probably of experts. I personally detest having post-hearing briefs, as is the fashion in arbitration. I much prefer that people should have a bit of time out and come back and do a closing speech, if necessary, with a speaking note if they think that helps them. So my instinct would be to go for a sort of 12-day period, which is going to be essentially 3 working weeks or a little bit. And it is no difference to me if we're looking at a January next year or whenever it is. Looking at my diary, the question is, what can you do? Do you have diaries to hand?
Yes.
Yes, and just to be clear, I am also in favour of Mr. Montague-Smith's suggestion of a small gap between the closing of the evidence and the closing speech, even if it's only 3 or 4 days. So, for example,
I'm very happy if we book out a 3-week period, then if you get through in two weeks, get through the evidence in 2 weeks, then you can have a couple of days out and come back and do your closing speeches fully prepared without in any way.
Yes.
So you can get a student if you're lucky, assuming we're allowed to travel by then.
Yes.
Yes.
I mean, I think we're looking at January realistically, simply because December, it's always a problem. There'll be Christmas and so on and so forth. So I would be looking at something in January. What have you got? You've got the option of either starting on the 10th or the 17th of January, so far as I'm concerned.
Your Honour, from our perspective, the only concern that we have is in relation really to trial preparation. I mean, I think, me looking at this, my estimate for the prep time for this would be about 4 weeks. So if you start on the day that we suggested, which is the 23rd, you're already looking at effectively eating into the last week of December. So trial prep's probably going to have to start in December to get for the advocates, and that will be me on this side, to get to trial start on the 23rd of January. So that's why we suggested that date as the start date. It seemed to us that the question really is, do we program in a trial now, which is going to either compress the trial preparation or push it back into a period when some people are going to be unavailable, or alternatively, do we just give the extra week? It's not it's been characterised as an attempt to delay. It's not. It's really a plea from those of us with families who will probably need to take a bit of time over that period for other purposes. So that's why we sort of programmed the preparation into January.
I'm sorry, I hadn't picked up there'd been a specific date put forward, but what date are you suggesting, Mr. Montague-Smith?
We suggested the 23rd, or not before the 23rd, the Sunday being the start date. The competing dates were in the paragraph, 23. So my learned friend had suggested the 19th of December, which we didn't think could work. We had suggested not before the 23rd of January.
I'm not doing the 19th of December, Mr. Strange, for obvious reasons.
Understood.
I have eight grandchildren. You may only have children, but I have lots of grandchildren who I hope I should be able to see.
Fair points.
Let's look at a sensible date in January, Mr. Strange. I mean, the reality is it's not, 3 or 4 weeks is neither here nor there in the overall scheme of things, is it? The important thing from your point of view is to get a date set.
No, quite agreed. And I'm just looking. I've got a calendar here with various of the team members' availability, and I think there's a problem with the week of the 24th.
Right.
So it looks like we'll be looking at February. I don't know what the court and the defendant's availability is like for the first weeks of February.
I'm told that from the defendant's perspective, that's fine.
Right. Okay. From my perspective, that's fine. January and February next year are both clear, pretty much, apart from very early Singapore thing in January. But I can do something beginning either the 30th or the 31st of January. Maita, do you know what the court's position is? Will the court be free then? No answer. I think you can assume it will be. Shall we fix it for then, and the court will revert if there's any problem that they suddenly discover they've got multiple trials fixed for that period?
Yes,
Right?
and if we could make it, if we could have effectively make it the 7th, the 14th, and the 21st, those 3 weeks of February.
I think it would be the 6th, the 13th, and the 20th. Starting on a Sunday.
Starting on a Sunday, yes, you're right. I was looking at Mondays. Yes, so 13th, 20th, and 27th. 6th, 13th, and 20th. Yeah.
Right. Movable feast, but at present you both would like to start on Sunday the 6th of Feb. Is that right? Is that what you're both saying? Sunday 6th Feb?
Yes.
Very good. I shall move my Sundays to Fridays in accordance with local practice, so to speak. It's always an interesting experience for a Christian to come to Dubai and go to church on Fridays, but that's good. That's fine. Okay.
Yeah.
So we'll put it in for 3 weeks, starting on the Sunday the 6th of February. And the court will confirm that to you or get back to you if there's any problem. You can take it that I'm free in January and February, so if it has to go backwards or forwards a little bit, there isn't a problem from my end. But we can liaise over that. Right. So far, otherwise, as directions are concerned, you're agreed, are you? And do I have an agreed order somewhere?
Yes, it's correct that everything else is agreed. I'm not sure that it's actually in a form of order. I think it's actually in a...
It is in the bundle.
Tab 12 of the CNC bundle, which is page 197. They're the proposed directions, and I think what we've just agreed would come in paragraph 23.
Bear with me a moment. Page 17, what did you say?
197.
197.
And my bundle's tabbed, and it's tab 12.
Yeah, I'm looking at this on electronic.
Okay.
Yeah.
So I'm using the red pagination at the bottom right-hand corner.
Okay. And we're clear about the nature of expert evidence that the parties want to adduce, are we?
We are agreed on the nature of the two experts, yes.
And basically one is simply real estate value and the other is the usual forensic accountant.
Exactly.
Okay. Fine. All right. Well, if you're both agreed on that, then you can agree the form of order between you and the court will issue it.
Yes.
There's nothing else you need to make me aware of that, as a judge, I ought to be alert to in the context of a hearing of this kind?
Not that comes to mind at the moment. I think that obviously in the world that we currently live in, whether this is a virtual hearing or in-person hearing is yet to be known. If it is going to be virtual, there will be probably further directions required and arrangements that will need to be made. But I think the parties can try and deal with that between themselves if the need arises, and then come back to you if there's any issues.
Your Honour, there is a provision in the timetable for fixing a pre-trial review.
I see that. I was wondering, though, whether in a case like this it might be more sensible also to fix an interim CMC at some stage, anticipating problems over disclosure or whatever. I mean, almost certainly I would deal with such matters in writing if required, but sometimes it's helpful to have a CMC fix which can always be cancelled. But perhaps you might like to think about that. If it doesn't make any sense, then don't bother, but looking for your good sense in that.
Yes,
the problem about fixing dates at short notice is it's difficult.
Understood. I mean, I think that what we probably ought to alert your attention to are the provisions in relation to document production, which will provide for there's a fairly tight timetable for applications for document production orders, and you'll see that at paragraph 6, 5 and 6. So if Your Honour is able to anticipate that applications will be coming in around then, we have a... Sorry.
It won't happen, Mr. Montague-Smith, because you'll delay. And my one comment on this order was that the thing I always put in arbitration in court is the court will use its best endeavours to determine the application by a certain date. Because what invariably happens, as you both know in arbitration in particular, is everything gets delayed and suddenly you want an urgent decision. And of course, dates are already taken up with other things. So that'll have to be a best endeavours point. But that's basically the reason I was thinking that it would be sensible to have, if not a formal CMC, at least a report on progression, so that one can see where we are in later on in this year, and that things are lining up all right. You know, in commercial court, the case progression monitoring report, whatever, progress monitoring report or whatever.
It may make sense, and if your Lordship has your diary handy, maybe if we aim to put a tentative date for that purpose in mid-July, and then we can always pull it out, because that's disclosure should be either completed by then, or there'll be lingering issues that will need resolution. And then witness statements aren't due till the end of August, so that would seem to be the opportune time to do it.
Yes. Well, let's look at July. July is very tight.
July is fairly tight for me as well, I'm afraid. I mean, it may be that I'm not required, but if we're fixing it now.
It would have to be in the week of the 5th of July, in fact. Well, the 8th is the last day of July, last day of the week, of course, the July working week.
Well, we could do it on the 8th of July.
Yeah, well, why not?
Yeah.
Why not? Let's put that in the diary for the 8th of July, and as you say, we can take it out if it's no use.
Well, that will become 7A.
Yeah.
Good.
Okay.
I think that's the easy part over with.
Yes. Where do we go next? Where do you want to go next?
I think it's probably RFIs and then costs, and I'm happy to proceed as you wish, and either go first on both, or have Mr. Montague-Smith go first on RFIs and I'll go first on costs. Very much in your hands. For my part, I can tell you I will be brief on both topics.
Yes.
Your Honour, it seems to be my application.
It's your application on the RFI, so you better get on with it, Mr. Montague-Smith.
I'll get on with it and I'll be as quick as I can, Your Honour.
I've read the paper, so I'm familiar with
I understand.
the broad thrust of where we're going in terms of the pleadings and so on and so forth.
Yeah, good. All right. So you'll have seen that we are pursuing 5 requests for further information. So 4 of them are about breach, and 1 of them is, my own friend says it's about quantum. In fact, it's actually about his restitution case. And you've seen I hope, my skeleton arguments, so you will have seen what I say about the requests themselves, and I won't repeat that, but if I may, I was just going to try to summarise the reasoning a bit. And what I'd say at the outset is there are obviously cases where these sorts of requests are a bit marginal, but this isn't one of those cases. This is actually quite important at this stage. It's important because it's not possible, we say, properly to understand what the case on breach in particular is. So Your Honour says you've had a chance to look at the case memorandum, you've seen the shape of the case, but can I just please show you what the case is on breach? You may not have had a chance to look at the pleadings themselves. It's a short passage of the particular statement of case, and you'll find it behind tab 2 at page 10 of the bundle.
I've actually printed out the pleadings, so...
Excellent. So it's page 7 of the statement of case.
Yeah.
And so the case on breach is set out in this section, which starts at paragraph 18, and it's set out in 5 paragraphs. But at the heart of it, really, and the only place where there is actually a positive allegation of breach is paragraph 19 of the statement of case. And so you'll see that what's said is that over time the defendants failed to comply with various obligations under the joint venture agreement, and they failed to do so as soon as reasonably practicable. And then they give the 5 breaches. So you've got, firstly, did not incorporate a joint venture vehicle. That's the first one. Then the second one is did not execute a shareholders agreement. And then there's did not execute a sale and purchase agreement. That's for the land. And then did not use best endeavours in good faith to complete those steps. And then finally, there's a complaint about promotion. So the focus here in relation to these particular requests, and I'll take you to them briefly, it is on the first 2, the joint venture company shareholders agreement, and also on the 4th, which is the best endeavours clause. And what we have at the moment is the assertion of the bare fact that, for example, these events were not achieved. So there was no joint venture company, there was no shareholders agreement. But as you may have picked up, part of the defendant's case is, well, these are mutual obligations. And so, as you might imagine, what we say is there's no way you can just establish a valuable claim by the claimants for the defendants failing to do something which the claimant was also obliged to do. One way or another, we say that doesn't work, but that's obviously not for determination now. But what is not clear, we say, is whether it's said that there are other specific events which gave rise to a breach, other than just simply the fact that those results weren't achieved. I'm sorry, I've been told that there might be an issue.
Yeah. So I'll connect the judge again. Yeah. So he just.
Sorry, if he's disconnected, could you just let me know?
He just disconnected. I just realized. Okay. One moment. Yeah. Thank you.
Thank you.
Can you hear me?
Yes, I can see you.
Can you say something now?
Yes, can you hear me now, Your Honour?
No, I can't hear you. I was on the phone connection and it's gone. I've just sent an email to ask them to re-establish the phone connection.
Can you hear either of us? Tom, can you hear me?
I can hear you, yeah.
I've missed virtually everything you've said so far, Mr. Montague-Smith. You've
What a
been
shame.
talking to yourself for quite a long time.
Doesn't bother me.
Some of your best work.
Yeah. I always win.
They has to phone me again. Hello. Thank you. Oh, right, I'm back again.
Judge, you might need to disconnect your video so that we don't have an echo.
Or mute it.
Or mute it.
Yes. Sorry, no.
Thank you.
Okay, I think that's all right now.
Good. Can you hear us now?
Lovely. Thank you very much. Mr. Montague-Smith, you'll have to start again. You were just about to address me on paragraph 18.
Ah, right at the beginning. What I was saying was simply that, firstly, the allegations of breach that are made are in paragraph 19, and there are 5 of them. They go from A to E, and they allege that certain things my client was obliged to do and didn't do, and they focus in on the results which the parties were required to achieve. So A is in relation to the establishment of a joint venture, B is the execution of a shareholders agreement, C is the execution of a sale and purchase agreement, and then at D there's a best endeavours obligation, use best endeavours in good faith to complete the steps, and then there's the promotion issue, which we don't have to worry about. So the focus here is on establishing the joint venture, the shareholders agreement, and using best endeavours in relation to them. Those are the breaches that we're focusing in on now. And so what we know is what's being alleged is that my client is responsible for those events not having been achieved. And part of the response to that is, well, those are mutual obligations in the contract. Both parties are subject to those obligations. And so part of the case is going to be that you can't establish a valuable claim for breach of contract for breaches which you yourself are in breach of. You don't have to determine that for today, of course, but we know that is part of the case that's being advanced. What is not clear is whether it is being said that there are certain specific events which gave rise to a specific other events beyond simply the
You still there?
I've lost Mr. Montague-Smith.
So have I. I'm sorry, this call is beset by problems today.
No, it's a sign of the times.
Well, usually it works comparatively well, but today is not good.
No, it's it's a small percentage that don't work. Otherwise, we've been lucky, I think, all of us. I will resist the temptation to let you know what he was going to say.
Or even reply in his absence.
Quite.
Tom Montague-Smith. Can you hear me now?
Yes, thank you very much. You got as far as talking about mutual obligations. No, can't hear you. Not hearing you at all, Mr. Montague-Smith.
Can you hear me now?
Yes.
Good. So I'm so sorry about this. I really don't know what's going on at this end, which is causing this, but I'll crack on, if I may.
Yes, I mean, it's just one of those things. We're having problems today.
Yeah.
You got as far as talking about mutual obligations in
Yes.
connection with the shareholders agreement and SPA and so on.
Thank you. I think the distinction I'm trying to draw is between, on the one hand, simply making a case based on steps not having been achieved, and on the other hand, asserting that there are other events which occurred which triggered further obligations. And so the example that I was going to give was in relation to the shareholders agreement, say, it's one thing to say that simply a shareholders agreement wasn't agreed. On the other hand, it might be said, well, a shareholders agreement was presented to the defendant, which the defendant refused to sign. And so that is obviously a very significant difference, but then it needs to be pleaded. What was the draft? When was it presented and to whom? And in particular, in relation to the best endeavours clause, there might be other allegations of breach. So, for example, one party might be said to block the process, which leads up to a concluded draft. There might be needs to resolve points of detail in relation to that, about meetings that parties were invited to but didn't attend, or something of that nature. Again, if neither party takes any steps towards, for example, agreeing a shareholders agreement, then we would say there's no basis for a claim. But if the claim is that the claimant did something which required a particular response, and that response wasn't forthcoming, then the facts on which that is alleged to arise need to be pleaded out. So, in other words, it might be the claimant's case that action by the claimant triggered a specific obligation to act in a particular way on the part of the defendants. Now, the pleading itself doesn't explain that, but it does gesture towards it, and we see that at paragraphs 18 and 22, and those are the paragraphs to which these requests are directed. So if you're on a scene, paragraph 18, we start there, it's on page 10 or 7 of the pleading. The claimant spent substantial time, effort and money in progressing the joint venture, including undertaking marketing and feasibility studies. And then this is the bit, it's the claimant also extensively engaged with the defendants with respect to the project, so it's the project on the one hand, including engaging with respect to the preparation of the shareholders agreement and pressing for the progress of the project. And if you go down to page 9 of the document, 12 of the bundle, paragraph 22, they say something similar in relation to the later period between 2012 and 2018. The claimant sought to engage with the defendant in various attempts to resolve the impasse, including by seeking to negotiate a replacement agreement, all the while maintaining a reservation of rights. And if there is this further case, then that's really it for particulars of this part of the claim. There's a bit more in the response, which I'll show you, but we say it doesn't really help very much. If you go to tab 5...
Can I ask a question here?
Yes.
Can I ask a question here, Mr. Montague-Smith? For my reading of the pleadings, I've only identified, I think, 2, so to speak, points of principle which appear from the pleadings in relation to why these agreements didn't get to fruition. One is the question of whether or not the investor could borrow, and the other is the question of whether the joint venture company's land could be used as security for any such borrowing. So those, I think, are the 2 points that I've actually identified as appearing from the pleadings. Are there any others which appear, or perhaps you're aware of, in relation to why agreement didn't emerge?
Why?
I know what Mr. Spring.
Yeah.
I know what Mr. Spring says about the defendant simply not wanting to reach an agreement.
Yes.
And I assume that will be the essence of his case. But in trying to identify, particularly over a period of many years, why an agreement doesn't occur in detail, one usually looks to see if there are some fundamental points of principles that divide the party, or whether there's some other reason.
Yes. So what happened was that quite shortly after the claimant became a party to this agreement, the parties began to discuss doing a different transaction entirely, involving a different company. And there were, in relation, in that was a completely different deal, in effect. Now, my learned friend says that was the shareholders agreement that was contemplated by the joint venture agreement, but we say that was a different transaction. Fundamentally, you will see some fairly significant differences. It's not simply the question of whether the claimant was entitled to borrow. That's not the case. The question is whether or not the joint venture company was to be the party which was to borrow. And that obviously is very significant, because our position is the claimant was going to be putting in all of the capital which went to the development of the land. Now, however they resource that, and we do say they weren't entitled to do it by raising money against the land. We don't say they're not entitled to borrow it at all. We say, A, they're not entitled to borrow against the land, the property, but B, they're not entitled under the terms of the agreement that was arranged to cause those sums to be expended for development of the land by the joint venture company. So that was, we say, a significant departure that was under discussion in a separate agreement involving separate parties on different commercial terms. The other part of it, and really if one wants to get to grips, we say, with the question of why didn't this happen at all, is because the joint venture agreement envisages a specific development, which, and you'll see it in the evidence which was filed in relation to the application for immediate judgment, all parties appear to consider was not going to be commercial by the time...
It's the mix of business, commercial, residential, offices and so on, is it?
And so on. That's one major part of it, yes. So what that meant was that the joint venture agreement, it appears, was never going to be one which was of interest to the claimant. And that is why we say the result was that both parties began to negotiate a completely different deal very shortly after the project was conceived. And in fact, I think that it's accepted that the original designs that were put forward were not a commercial design. They required a different mix of use, for example, and they were redeveloped on a number of occasions over the course of the negotiations. And so it got to 2012, which is the date, which is when the defendants issued a letter. Or one of the defendants issued a letter on which the claimant relies to say that was a renunciation, an anticipatory repudiatory breach of the contract. And then there's dispute about what happened next. But we say during that whole period, what was under discussion was again a variation of the joint venture agreement. Neither party was really directing itself at going forward with the deal that they had previously agreed. And then towards the end of that period, various different options were presented to the claimant, one of which was to sell its interest and to somebody else, but no deal was agreed. But we say that certainly towards the end of that period, the position the defendants took was, look, we will try to arrange a different deal with you, but if we cannot agree, then we'll go back to the original deal and progress it. And then you get to October 2018, which is when the defendants sent a letter saying, let's get on with it then. And very quickly in response to that, we get a response from the claimant saying, actually, you're an anticipatory breach, you don't intend to proceed with the contract, and that's when they terminated. So the bottom line is that the question, why didn't this transaction take place, has in part to do with the commercial differences on the shareholders agreement itself, but really at its heart we say it's more about the commercial reality of the project that was envisaged, because we say that the defendants say let's proceed, the claimant says well actually no, let's terminate.
Let me ask another question then. I mean, I understand that, but in the context of what you're hoping to get by way of particulars, are you thinking that what you are likely to get or what you ought to get is Mr. Strange saying that on March the 10th, 2007, we put forward a shareholders agreement draft in this form, which contained the following elements, and you should have said yes or negotiated something similar?
Yes, effectively, and they do say that in relation to the shareholders agreement that was negotiated and to some extent signed, I'll put it like that, neutrally, in February 2008. Yes. So that we hadn't understood, for example, from their original pleading, but now we do understand it to be their case, that shareholders agreement was consistent with the terms of the joint venture agreement, and that's fine. We can deal with that. The question is, were there other shareholders agreements at any stage during this 15-year history which were put forward, or terms in respect of which were proposed, which it's being said, well, that triggered an obligation on our part to sign up to it or progress it or do something else? That's the question, because otherwise what you're left with is simply the bare assertion there was no shareholders agreement. And then the court is left with this question, well, whose fault is that if the obligation is on both parties, and that's it, there are no other facts relied on, then it's very difficult to see how you get to a valuable claim, as I say. So what we do, if I can show you the requests, and you will find them on page, well, if I can show you just one other request first, it's tab 5, page 110. This is the other part of it, just to explain how the case is put. If you go down to 110, you'll see request 12, and I'll come back to this. But one of the things that we ask, because limitation is obviously going to be a big issue in this case, we're dealing with events that are very old. So request 12, please confirm when each cause of action relied on is alleged to have accrued, including all the facts and circumstances relied on. So it's a general request for time-referenced allegations of facts supporting particulars of breach. And the response comes back without prejudice as to whether breaches were one-off breaches or continuing breaches, which is a matter of legal submission. The breaches all crystallized in September 2012. So again, you see, timing is important, but the point here is that the facts and matters on which the breaches are alleged are not set out beyond the bare fact of the results that were not achieved. So we say there's a real problem with the way in which the case is expressed on breach, and that's what the request is attempting to grapple with. And it's two requests, 4 and 5, which you'll find further up on pages 104 and 105. And so request 4 is directed at paragraph 18, which we looked at, which is the extensive steps in progressing the project, engagement on the shareholders agreement, pressing for the project to proceed. And so in relation to the shareholders agreement, we ask for 4A details of the drafts of the shareholders' agreements that were under consideration and the dates on which they were provided. Now, it may be that there are no other drafts which were prepared that are relied on. But if there are, and if there aren't, then that's fine. The claimant can simply say that there are none, and that's the end of that. Rather than this rather vague assertion that there was, quotes, engagement in trying to agree to a shareholders' agreement. And paragraph 4b simply asks the same question, but in relation to oral engagement in relation to the shareholders' agreement. And so asks those questions, well, if what's being said is somebody asks somebody orally at a meeting, say, then when, where, and to whom were the relevant statements made? And that's necessary to be able to investigate and prepare the evidence in response. So it's that rather standard request in relation to oral statements. And then 5.
Well, there's a slight oddity there, Mr. Montague Smith. I don't think you were responsible for drafting the request, but the request under paragraph 18, in one sense, looks more like a request that ought to have been made under paragraph 19, B and D.
Yes, I can see that.
The defendants did not execute the shareholder agreement as required. You could have asked, well, when should they have executed the shareholders agreement, and what shareholders agreement? Yes. I mean, in a sense, that's the nub of the point, isn't it?
Yes,
and likewise,
that's what this is trying to get at.
What steps did they not take in exercising their best endeavours in good faith that they should have taken?
Correct.
There's case law on what best endeavours means, as I'm sure you know.
Yes.
And that's all about what steps should have been taken that weren't taken, that a reasonable man looking after his own interests and taking into account the interests of the other party would take, and so on and so forth.
Yes.
I don't. I want to get to grips with the matters that are really important here, without focusing necessarily on the technical details of how the request is framed. Yes. But in one sense, would be better framed under 19 than under 18, wouldn't it?
Well, I can see that. I mean, I think what I'm trying to express is why the requests were put in this way, because it's really we're not trying to elicit, I think, a whole new case. We're trying to understand the detail of the case. Yeah. Why is it that these steps in engagement, in presentation of shareholders agreements, whatever they may be, are being relied on under a heading of breach to establish a breach of contract? And the first step in that is to understand what is the relevant conduct that's being asserted. But I do understand Your Honour's point in relation to that, and I can see that a different draftsman might have put it slightly differently. But as you say, what's important, it seems to me, in a case of this scale, both in terms of the evidence that we're going to get, but also in terms of the value, which is quite significant, is that we understand what the parameters of the case really are from the outset.
Yeah. All right.
And Your Honour's observation probably also applies in relation to request 5, which is dealing with the progress and engagement on the project more generally. How is it that led to a breach? So insofar as these, we're not asking for every last detail in a pleading of all the engagement. What we're asking for is the engagement and the steps which are relied on as supporting the breaches that are alleged. So that's those steps. And then in relation to B, again, we see particulars of the oral communications that are relied on. C, we don't have to concern ourselves with, because that is not being pursued in this application. And the response you will see in relation to both of these is really the same. It's said that this is a request for evidence, and also that some of the information can be found across various paragraphs of various witness statements.
Yes. Well, I've read all those.
I'm grateful. So we can see there are two ways that this could be. It may just be that these are simply background, and so the engagement and pressing isn't in fact relied on as triggering any specific obligation. But if that is the allegation, then we say that they ought to say so, and it can't just be waved away as being evidence. We're looking for facts. And actually, if you say, Your Honour said that you've read the relevant paragraphs, it's not possible to work out from those paragraphs which facts are being offered as supporting an allegation of breach. If you've read them, I won't take you to them. But I mean, in relation to request 5, the reference is to 122 paragraphs of 2 witness statements, which is about 45 pages of A4 in relation to that. So again, it's not possible to identify what facts are being asserted as giving rise to a breach. In the skeleton in relation to these 2 requests, 2 points are made. First, it said, well, we've already filed a defence, so we must understand the case. But that clearly doesn't follow, because pleadings aren't just there to be pleaded to, they're there to shape the scope of the evidence that needs to be presented. And so we are able to say we don't consider that there was any breach, but we still want to know what specific allegations of breach are being made. And secondly, it said that requests 4 and 5 are answered by paragraph 11 of the reply. So I should show you that, Your Honour. You'll find it at page 89, it's tab 4, and paragraph 11 of the reply, you can see, starts on page 7 of the document.
Yeah.
And you can see from the top of that page, this pleading is in fact directed at the defendant's case of estoppel. You may have seen there's an issue as to whether or not, whatever the meaning of the contract, the claimant is able to say that the joint venture company should have been established even before the shareholders agreement was agreed. And so part of the defendant's case is that the claimant has stopped from saying that because everybody effectively agreed that incorporation would follow the shareholders agreement. And so you would not read this section and understand it to be the claimant's particulars of breach. First, that is not the function of a reply. But second, if you go to paragraph 11 and look at all the events starting from A to G, you will see all of those events occurred between 2007 and 2009. And in fact, in H, which you see on page 91, that does deal with events in 2012, but only in April 2012. And as you'll recall, what's being said is that the breaches occurred, or crystallized is the word that's used, in September 2012. So it's completely unclear what is actually being relied on as breach. And in any event, if you look at the beginning of paragraph 11, the last sentence of that, you'll see the word included. So what's being said, it seems, is that this is not comprehensive. And even if it is said to be comprehensive, you'll see that actually it's not particularized either, because in A, there's a reference to 46 communications and chasing for on a weekly basis. But more generally, as I say, it's not an appropriate place to plead your claim for breach of contract. Ultimately, what we're looking for is a complete list. And if it is being said that the list in paragraph 11 is complete, if that is genuinely the claimant's case, then they can say so. Why they had to put it in a reply rather than a response to the request for information, we don't know. But otherwise, we're left with the current response on the pleading, which is, we will tell you later. And so we are looking for confirmation that that is the complete list of events or steps taken by the claimant, which should have prompted some response by the defendants. And while they're at it, they should provide the missing particulars from paragraph A. So that's what I have to say about the first 2 requests, 4 and 5. I can go on and deal with the other requests now. Alternatively, you may want to listen to Mr. Sprange on those. I'm in your hands on that.
Why don't we deal with 4 and 5 now, and then go on to deal with the other ones later? I think that makes sense, Mr. Sprange.
Thank you.
Happy to do it that way, My lord, I'll deal with 4 and 5, but before I get into the details of 4 and 5, can I just draw to your attention some overarching points? The first is that the reality of this case at trial is that unfortunately your lordship's going to have to get into the weeds of the chronology of the parties' dealings from the signing of the agreements all the way through to October 2018. And you're going to get evidence in the form of documents and witness statement evidence from both parties that walks through those periods, and the parties will have a different gloss on who was doing what and who was at fault. I think your lordship's correctly identified the real difference between the parties in terms of the financing questions, and from that will flow the parties' disagreements. So this is not a case where either party is under any illusions that it needs to put its version of the chronology of events over an extensive period of time. So having some particulars here and there about whether drafts of agreements were provided and what one particular party said on a particular day isn't really going to help anybody in terms of understanding the case. So that's the first point. The second point, these are really more in the form of interrogatories, because what they do is they don't arise in circumstances where the defendant doesn't understand the case. And I'm going to take you to their pleading in a moment to show that they clearly do understand the case. They've considered the issues and they've put a positive case, and in some cases made concessions as to the pleadings that we have put in. And so really what they're trying to do here is to narrow down the claimant's case early on, so they can avoid having to deal with things and perhaps disclosing documents. So we say don't be seduced by this suggestion that these are requests for further information. They're really interrogatories. And so, my lord, if I can go to the pleadings, and I will say this, that the reason you file RFIs, whether it's in England or here, is because you find it difficult to plead the defence because you don't really understand the case that's made against you. And you are afraid that if you put in a positive case on something you don't understand, you'll need to amend it later, or there'll be procedural problems. Here, it's abundantly clear that the defendant not only totally understands the case, but has taken a positive position. Now, I'm going to assume you have a reasonable knowledge now of the particulars, and if I could ask you to take up the defence, which is at tab 3, and I want to go straight to page 68, I-68, or page 8 of the internal pagination.
Yeah.
And it's paragraph 18. So you'll see there that it's denied, or it's not admitted that we put time, effort, and money in, and we put strict proof, or that those costs were incurred at our own risk. Then the balance of paragraph 18 is admitted, except there's a denial that we pressed, and the particulars of that denial are that we never complied with the JVA because we didn't propose something that complied with it, and that we didn't take any steps to incorporate the joint venture company. What's then said, and if you look at paragraph little I, so it's 19AI at the top of page 69, Your Lordship will have seen that these 3 representations, and the nub of those representations is that we allegedly represented that the JV company didn't need to be incorporated until we'd reached an alternative agreement. And so they're saying they didn't have to comply with those obligations because we made these 3 representations. And then if you look at B, they simply say no shareholders agreement in a form prepared by Nexus in accordance with the provisions was approved by the claimant or defendant for the reasons set out. And essentially, my lord, that goes back to the representations. D and E are over the previous page, and it's the point about departure from Schedule D. Schedule D has the financing provisions, and E is the liquid finance. So when they obviously with a statement of truth and having carried out investigations, they were very comfortable denying breach on the basis of A, the representations, B, having never got a shareholders agreement, they say, in the form that was required, and inconsistent with the representations that were allegedly made. My Lord, if you then go over the page to page I-70 and you look at paragraph D, they say there that there were time-based obligations, and of course, as you will have seen, we say they're not time-based. It's a continuing obligation that is in place for the entirety of the term of the JVA. And then they say here, accordingly to the extent that the clause 3.12 to 3.14 were action-based, those are what we've defined as the clause 3 breaches. They were not absolute and were subject to the qualification the parties need only use their best endeavours. The defendants were not in breach of any of those obligations for the reasons set out in 19A to C, which is basically what I've just shown you. So, my Lord, they've understood the case, they've made the case. They must have made that case on the basis that they knew very clearly that having looked at all of the documents, we never complied with what they say are mutual obligations, and therefore we can't pursue those claims as a breach because we were in breach ourselves. Now, you can't do that unless you know the answers to the things that they now seek particulars of. And this is probably best seen, my Lord, when you go to the case memorandum and agreed list of issues. You'll see that at tab 10. It starts at page 182.
Yeah.
And if you please look at page 185, paragraph 7. It's at the top of page 185. The defendant's case is that the contracting parties, and you'll see there the point that you've already alluded to. You'll then see at paragraph 10, you'll see our case that there was sporadic negotiations. And in that same paragraph, it's the sentence starting, the defendant's position is that the parties were discussing a number of alternatives. And you'll see that there. So, my Lord, the battleground is very clear. We are saying, as we do in paragraph 18 and 19 of the particulars, you were supposed to do these 4 or 5 things. You did not do them, so therefore you are in breach. You'll see the defendants then say, we didn't have to do them because they were time-based. But in any event, we didn't have to do them because of representations you made. And because you never did the things that you were supposed to do, in particular, present a compliant proposal. So that case and the battle lines are very clear. It's not going to be helped by a little bit more detail here and there about conversations. I'm not going to show you the reply, my Lord, because you've seen it, and I know you have read the statements, but if I could just take up one statement and show you that. That's the statement of Mr. And I'm going to ensure my pronunciation is perfect by trial, but Mr. Hosson, H-O-S-N, which is at tab 8, and starts on page I-144. If you could, page 160, I-160, if you could go to that.
Thank you.
So here, what he is doing is he's responding to Mr. Visser's allegation that between September 2012 and October 2018, that they couldn't come to any agreement. And what he's saying is that that's not fair, that what was in fact happening was that the defendants were stonewalling and playing games. He then goes in to what I would call considerable detail as to what then happened. And if you could pick it up on page 164. Sorry, I misspeak. Pick it up at page 161 163, sorry, it's paragraph 45.
Yes.
And you'll see there my takeaway from, and he's referring to an email that had passed, we're up to their usual tricks in trying to get rid of Hexagon, and he puts some details. He goes on to describe events in November 2013, and then he talks about the negotiations between 14 and 18. And he says in paragraph 48, 10 meetings with the DIFC, further details of which are set out as follows. He lists meetings throughout that entire period, and then he puts colour into some of the things that were going wrong. 54 on page 166, we did not hear back for several months despite my making a number of chasing telephone calls. 58, he summarizes his notes of a meeting in May 2017 where he asks Mr. Visser, and this is 58.3, why the process of entering into a new JVA was taking so much time. Paragraph 60, they went quiet for almost a year. And he says in 61, DIFC were again were seeking to wipe the slate clean and start over. So I'll give you those just as some examples of the kind of information that the defendants plainly have and have had for some time, and had for the benefit of drafting the defense that I've just shown you. And the notion that they're going to be helped by any more detail is, I suggest, rather fanciful. The last point I want to make on the specifics before I turn to the response that we've given is if you do look at the reply on page 189, so it's 1-89, paragraph 11, it's tab 4. It's correct that it's in response to the alleged representations, but of course the alleged representations were made or pleaded as a response to our allegation in paragraph 18, 19 and 22 that we were pressing. So what we've said in the reply, and they are particulars, is that between 2005 and 2012, we repeatedly pressed the defendants to perform their obligations under the JVA. Well, we know what those obligations are. They're the clause 3 obligations, and the ones that we've specifically pleaded that they were in breach of in paragraph 18, 19 and 22 of the particulars. So here we're saying we pressed them to perform those between this period, and then we put all of those dates and times. Now, the defendants may argue that that's a weak case, or that they've got good responses to it, or that the suggestion from us that crystallization in September 2012 is wrong, and it's in fact April 2012. They may say all those things, but they can't say they don't know what our case is on being pressed. So what you really have here when we go to the response, and that's at tab 5, page 104. So let's look at 4A. Well, the position in relation to the shareholders agreement, they've effectively admitted it, and I've shown you page 68 of the bundle, which is paragraph 18 of their defense, where they don't really take issue with us engaging with them about the shareholders agreement. What they say is that they never got one that was compliant, and further, there were these representations that there didn't need to be until we had a new agreement, then a new JV company, and then the new shareholders agreement. And if you then look at request 5, when the claimant engaged with the defendants or pressed for the project to progress, well, they know that. They know we say it's from the date the agreement was signed until we terminated it. And in terms of the oral statements, I say that. So this is B. That's really interrogatories. That's not a request so you can understand a case. Not only have we pleaded as to that, we have also given them a pretty detailed statement with some specifics as to a number of meetings. And we've said what we said at the meetings and what we thought they were doing. So there's simply no basis for the defendants to say they can't get ready for trial and understand our case and the case that they have to present. They clearly do, and they've probably got a lot more than a party really does. So for me, my lord, as I look at this, the rugby analogy is the ball's gone into the scrum. It's gone to the 9, to the 10, all the way up the back line to the 15. And now they're suddenly saying, having understood all of that, that they didn't understand the directions as to, from the referee as to how to pack the scrum. Well, clearly they did, because all of this has happened. And we're now at a situation where we've got an agreed list of issues and a case that's going to go to trial with the nitty-gritty of the chronology to be presented by both parties with their own gloss. And as I sit here, if we were required to do 5B, we couldn't possibly do it until such time as we had disclosure, ours and theirs. And then we sat down with our witnesses to prepare their witness statements for trial and went through in a lot of detail all of the potential meetings. And what we would produce would in fact be a witness statement alleging all of these points and addressing in detail the pleaded defence that you see at paragraph 18 in terms of the representations, and also the notion that we didn't present a shareholders agreement and a JV agreement and financing obligations in accordance with the JVA. And what's more, the defendants will be doing exactly the same, but supporting their case theory. So all in all, we say these are interrogatories. They're not required for them to understand their case. And the best way for all of these points of excruciating, intricate detail to be dealt with is witness statements post-disclosure. So, my lord, those are our submissions on 4 and 5.
Thank you very much.
May I just say something very briefly in response, Your Honour?
Yeah.
Thank you. I mean, it's interesting the way that my learned friend puts it. He accuses me of trying to narrow down the claimant's case so that the claimant doesn't have to deal with things that arise in disclosure. He says he can't give particulars until, for example, the engagement that's relied on, until he goes through disclosure. And then he says, well, there's a series of examples that he gives from the evidence which he says might be relied on. And the problem, of course, is that we don't know, in that long chronology that's given, which of those facts are going to be important. I had the unpleasant experience of doing a trial in the commercial courts over the course of a week on Part 8 claims. So it should have been a Part 7 claim, but because it was Part 8, there were no pleadings. And the result, I'm afraid, Your Honour, is you will hear cross-examination on a vast range of completely irrelevant matters that don't make any difference to Your Honour's judgment. The whole point of pleadings is to identify which are the facts and matters that matter, which ones are relevant, that goes to these questions of breach. And simply saying, well, we answer the case is not a response, because, of course, our case, for example, taking the example my learned friend gave of the shareholders agreement, our case is that we didn't receive any shareholders agreement that was compliant. What we need to know is what is said by the claimant on that. What documents are relied on? Are there documents which were provided, which the claimant says were compliant? And then we can engage with it. Otherwise, we're going to end up at trial arguing about all manner of documents, and 3 weeks is never going to be enough, Your Honour. So it's about trying to frame the case so that we can answer it, but also so that we can present it in an orderly fashion to Your Honour, and not have to traverse through every single last detail on the off chance that it's relied on in closing as being of some importance.
Right. Okay, thank you very much.
Your Honour, I was going to deal with the next 2 requests together, if I may.
I think it makes sense for me to deal with these requests now, make a ruling on it now.
I'm grateful.
So I'll do that. The requests under paragraph 18, requests 4 and 5. Request 4 is of the phrase the claimant has extensively engaged with the defendants with respect to the project, including engaging with respect to the preparation of the shareholders agreement, making presentations with respect to the project, and pressing for the project to progress. The plea is general in form and obviously doesn't descend to any particular detail in relation to specific drafts of shareholders agreement or specific presentations or specific steps taken to press for the project to progress. I suggested to Mr. Montague-Smith that in practice some of his requests would have been better perhaps put under paragraph 19 in the context of the failure to execute the shareholders agreement and the failure to use best endeavours in good faith to complete, quote, the aforesaid steps and procedures, by which is meant the incorporation of the joint venture company, the execution of the shareholders agreement and of the sale and purchase agreement, inasmuch as what really is an issue is what steps were taken by the claimant to which the defendant should have responded. What steps were not taken by the defendant that they ought to have taken. Those are the key questions that matter. And whilst I understand entirely what Mr. Sprange says about the need for disclosure and witness statement to descend into all the details of chronology, I think it is necessary at this stage for there to be greater particularity as to the basic steps which were taken, to which the defendant should have responded, and the steps that the defendant didn't take that it ought to have taken over the extended period of time between 2004 and 2018. Of course, the defendants have been able to plead a case, in essence, to say that no proposals ever came forward which were compliant with the shareholders agreement, that the commercial basis of negotiations changed because of the business and residential and office mix of the project, the particular land that was involved, and the suggested change in parties. But I do think the time has come for something more particular to be given than that which appears on the face of the current claim and paragraph 11 of the reply. I have no doubt that paragraph 11 of the reply would feature in part in relation to the particulars, but I doubt if that's comprehensive. If it is comprehensive, then that, of course, can be said. But if one looks at it as it stands, simply as a matter of pleading, then it appears to me that the defendants are entitled to particulars of the engagement, as it's put, the engaging with respect to the preparation of the shareholders agreement, and would be entitled to particulars of when, where, how, whether orally or in writing, and identifying the documents relied on, as occasions when there was such engagement, what presentations were made, and when was there pressure put for the project to proceed. I don't envisage something on a day-to-day basis. That would be quite impossible, as Mr. Sprange said. There will be matters that will be dealt with ultimately in witness statements following disclosure. And it may very well be that the particulars that are given will begin with the usual words and the best particulars that can be given prior to discovery and or interrogatories are. But something more must be done to identify in particular, it seems to me, the draft shareholders agreement that were put forward that are relied on, to which it is said that the defendants should have responded in one way or another, and what in broad terms is said about the response they did and didn't make. So I'm not framing the request for Mr. Montague-Smith. It's there as it stands, but essentially it comes to the request that if it's alleged that draft shareholders' agreements were prepared or put forward, then identifying when and where and by what means that occurred, and identifying all the material documents relied on, including the relevant draft shareholders' agreement. It's plain to me that the draft shareholders' agreement is really the key to all this. Points can be made about the order in which incorporation of the joint venture company should have taken place and the like, but that would have been quite futile unless there had been agreement on the shareholders' agreement, and the sale and purchase agreement likewise would follow from the agreement to the basic principles upon which the deal was to proceed. So I don't regard this as a request for evidence. I don't regard the reference to a multiplicity of paragraphs in the witness statements as giving the required particulars. It's not for the defendant to trawl through a witness statement to find answers. Proper particulars should be given, setting out the basic points that are relied on in the course of the history between 2004 and 2018. And what I've said there in relation to request 4 is equally applicable to request 5. And the only reason why I've gone into any degree of detail in relation to these matters is because I think that the request is not as clearly formulated as it might be, and I don't want Mr. Strange to think that he's got to descend to the day-to-day particulars that he suggests are impossible at this stage. But it is nonetheless a question of setting out, well, this is the basic shareholders agreement that was brought forward on this occasion, this was the shareholders agreement brought on the other occasion, your response was wholly inadequate, and therefore you are in breach of your obligations one way or the other. I hope that's sufficiently clear. I'm simply going to grant the application in relation to the request, but with the qualifications that I've given, so that I hope it's clear what is and what is not required. Mr. Strange, can I ask you, are you fairly clear about what it is that I'm expecting to see and what I'm not expecting to see?
Yes, is the answer. Just one point of clarification on detail, and then one in just logistically. If I look at if I look at 4A, for example, that would be shareholder agreement drafts. I think I took a note of your ruling that identify draft of shareholder agreements, and then responses that were made or not made.
Yes, if you put forward, 4 different drafts on various occasions, for example, you can identify those occasions and say, well, this was perfectly in accordance with the JVA, and you simply dead-batted it, to take a cricket analogy as opposed to a rugby analogy.
Yes.
And you weren't in good faith in relation to that because you never wanted to do the deal at all, or whatever it is you do say.
Yes,
but
and
that's the point. I think we've got to identify
yes, I understand
sufficiently the major steps that you took and the major steps that you say that the defendant failed to take.
Yes, and so that would be, as you say, they didn't do X and didn't do Y, or they did do X and Y and they shouldn't have, and they did it on 4 occasions, including 3 meetings on these dates and by these 5 letters. Rather than going to the detail of exactly what was said at each meeting or in each letter.
Exactly so. And you know, if you're saying, well, they did nothing over the whole of this period, you know, there's a whole period when they deliberately didn't respond at all or whatever, well, you just say that.
Yes, no, that is perfectly understood. The second point of clarification, and it's
if there are major meetings, I'm sorry, Mr.
Yes.
Strange, if there are major meetings, and I understand from the witness statements there are one or two major meetings that are relied on, then again you should say that.
yes, yes.
At the end of the day, after all, people have got to prepare witness statements on the basis of the pleaded case, so they need to know what are the essential points they've got to grapple with in the witness statements.
Yes, no, that's understood. The second point is more a practical one, and I understand that this is slightly changing the complexion of the application, but it does strike me that when I look at the kind of particulars that your lordship wishes to have, and I look at the way the request is done, which is of paragraph 18. And there's points that it really probably arises in paragraph 19 and 22. Is this not more of a situation where there should in fact be an amended particulars of claim, because that would be a lot cleaner and a lot more tidy than having further particulars in separate documents. And I say that just for selfish reasons as well as practical ones, in the sense that if the claimant does that and has a markup of the particulars of claim, that's going to be easier for the court and also for the defendant to understand and deal with than if we're looking at sort of disparate documents, which RFIs are, and this will be an amended response to an RFI. So it's more of a suggestion than anything else, but it seems to make more sense, particularly if we've got more than one, that is more than paragraph 4. Or sorry, request 4.
Well, no, I think that makes very good sense, provided that the particulars are in the new amended particulars of claim.
Yes, yes, yes. Oh, very much so. Because what I'm envisaging is, my apologies.
Mr. Montague-Smith, you'll be quite happy with that, won't you?
Well, my concern is about what that's going to do to the timetable, Your Honour. Because is it being suggested that these are going to now be pleaded in the particulars of claim? That's going to take a little while to amend. Then presumably is it being said that we then need to plead a defence to that, so we need to amend? And then is it being said that there then needs to be an amended reply? I can see that process pushing everything back by another month or two, frankly. So the concern now is that, you know, ideally this would have happened already. As long as we've got the pleadings, as long as we've got the particulars out there, then we can deal with those in, it serves the purpose. We can deal with them in relation to documents, we can deal with it on evidence.
I certainly wouldn't be suggesting that there be a full recast of the pleadings. As I see it, we're providing particulars of something that the defendant's already pleaded to, and all we would be doing is putting in more detail. So we certainly wouldn't be suggesting that there be an amended defence and an amended reply. And the other point is, I don't think it makes any difference in terms of the timing, whether we put them in RFI form or particulars form, in terms of when we get them to the defendants.
I think that the difficulty with that, and that's fine if Your Honour's happy with it, but the difficulty, as long as everybody understands that the statement of truth in our defence, or in fact our amended defence, I think, is directed at the original pleading. So when we deny a paragraph, for example, we're not necessarily denying the existence of a meeting or something of that nature. I think that's, if everybody understands that that's the position, then we can go forward on that basis, and it doesn't matter whether or not the information is provided in a pleading or in a response to a request. It'll be a schedule form, I imagine, and a relatively substantial document in any event. But yeah, I can see problems, but. Yeah.
I understand the reservation, but the reality is that whenever new particulars are given, there are times when the other party thinks, well, I need to actually plead to those because I haven't pled to them before. And that can happen whether the particulars are incorporated in a newer amended points of claim, or whether they come in a separate document. So that's a bridge one has to cross when one gets there, I think. So I don't think there's any difficulty in it all going in the amended points particulars of claim. And then you'll just have to consider whether there's something that needs to be pleaded to by way of amendment. I'm not encouraging people to do that, and nor is Mr. Strange, but it'll be perfectly clear from the dates as to what's been pleaded to at what time.
Understood.
So I think cross that bridge when we get there.
Thank you.
Right. I think that's sufficiently clear on those particulars. As I say, in terms of the order, I shall simply order the particulars to be given, and there can be the proviso to the order that they can be given in the form of amended particulars of claim.
Thank you, Your Honour. In light of that discussion, I hope we can take the other ones rather more quickly, because Your Honour now has the context and the basic rationale for them. The first one, the next one is request 8, which you will find on page 107 of the bundle, and it's directed at paragraph 22. So it's effectively the same issue, but this time in relation to the later period, 2012 to 2018. And so, in other words, again, what actions by the claimant are being relied on as giving rise to a breach during that period? What is it that the defendant should have responded to? In particular, and then in particular as well, it's not confined to, but in particular, we're looking for oral communications relied on, and you will also see reference to oral reservations of rights at 8B specifically. The response to all of this has been the same. It's a request for evidence. There's reference to 51 this time paragraphs of witness evidence and various other pleadings and other documents. Now it's said as well that paragraphs 13 and 14 provide those particulars, and it's just worth turning those up very quickly. You'll find it on page 91 of the bundle. So it's paragraphs 13 and 14, and you'll look and see that is under the heading alleged affirmation. So part of the case, from my side, is that insofar as there was a renunciation in 2012, it's far too late to terminate in 2018. And part of that is because it said they affirmed the contract, and the other part of it is it's because it said that by the time we get to 2018, the defendants had said, let's go ahead. So 13 really deals with the first aspect of that, and 14 deals a little bit with affirmation, but partly with the second point. It's not obvious that is directed at the point that we're actually dealing with, which is the breach. Are there other breaches which are alleged coming after 2012, other than simply the fact of not achieving the goals that the parties agreed they would achieve? And I'd say there's nothing, even when one gets to affirmation, as you'll recall, one of the requests is directed at affirmation. There's nothing there about any oral reservations of rights. Now, it may be that there are none, in which case the claimant can just say so. But some conduct of the defendants is referred to in these passages. But as I say, the primary aim is to show that the claimant's right to terminate was kept alive after 2012. And so it's not clear what, if anything, is said about breach, and it may be nothing. I was going to deal, just for time purposes, really, with the other two requests together now, straight away. The next one is request 12, which you will find on page 110 of the bundle. And in a sense, this is closer to the sort of request that Your Honour asked me about. Wouldn't it be more sensible just to say, what is it that is said that should have been done that wasn't done? This is in part aimed at that and in part aimed at limitation. So the request is in relation to each cause of action. When did it occur? When did it accrue? and all the facts and circumstances relied on by the claimant in determining the accrual of the cause of action. So that is perhaps a bit more close to, when you say we're in breach, what are all of the facts and matters that are alleged to give rise to that breach? So timing is important because of limitation, but then there's the general request. And as you've seen, the response that comes back is all of the breaches crystallised in September 2012, but it said there may have been continuing breaches after that, and that's a legal argument. Of course, it's a matter of legal argument as to whether there's a continuing duty, but the question of whether there's specific breaches is a question of fact, and there's simply no response to the request for facts on which the allegations of breach are based. And so, again, I mean, we're back to the same point. If it's the bare point that the results weren't achieved, that's one thing. But if it's said that the engagement and pressing gave rise to something specific that should have been done, then that needs to be said. Now, it may be that the particulars that are provided in response to the other requests, the three that Your Honour has been referred to and the two that you've made an order with, may cover this. But if they don't, then this is a sort of sweep up, but also asking the question about timing. What is now said is that this is all responded to in paragraphs 16 and 17 of the reply. You will find that on page 98, Your Honour. Uh, 16 really just deals with the bare facts that the results weren't achieved, no company incorporated, no agreements entered into. And the pleading, I say, actually adds a little bit of confusion there, because what it says is that this is the second line of paragraph 16. The breaches, the final line, crystallised in around September 2012, by which time the defendants had not done these things. So it's not obvious on the basis of that pleading what's so significant about the September 2012 date, because, for example, one could say exactly the same sentence, but include 2010 instead of 2011. One could say they hadn't crystallised as by 2010. Those things similarly had not occurred. So why is that? What's relevant to the so-called crystallisation of these breaches? None of that is explained. As I say, it may be that the claimant can cut that short as well and say we don't rely on any specific conduct after 2012. And if that is the case, then that will clarify things and shorten things. But if it's not the case, then they should say so, and we can get on with it. So that's request 12. The final one, which I can deal with very quickly, is request 13, which you will find on page 110 as well.
Yeah.
So this is a discrete inquiry about the way in which the loss or quantum is pleaded. But in fact, if you see it compressed into one sentence, is a case on liability as well. It's probably best to look at the pleading in context, if we may, just very briefly. It's page 14 of the bundle, tab 2. Paragraph 28, you'll see, as a result of the claimant's lawful termination of the joint venture agreement, the claimant is entitled to seek restitution and damages. And then paragraph 30A is where the request is directed. The claimant seeks an order for a sum of 1.75 billion dirham, such sum to include the following, and it's A that is the problem here: the restitution of any sums contributed directly or indirectly by or on behalf of the claimant. So that appears to be a claim for unjust enrichment, and as Your Honour will obviously know, the essential elements of that are the enrichment of one party at the expense of the other in circumstances which make it unjust. Now, no doubt the circumstances which make it unjust are the termination of the joint venture agreement. And so monies paid in anticipation of an agreement which doesn't happen or is rescinded, one can see that there's potentially a restitutionary claim there. But the main essential elements are unknown. What is it that was paid or provided how were therefore the defendants enriched, and how is that to the claimant's detriment? And so we seek particulars of that by request 13.
Okay.
That's it, Your Honour, in terms of clarifiers.
Thank you. Mr. Strange?
I can take this very quickly, my lord. In relation to 6 and 8 and 12, if you're not persuaded by what I have already said and the provision of the extra particulars on each of those points in the reply, then we are happy to proceed consistent with the ruling you've already made by way of an amended particulars. So that is in
That makes
short.
pretty good sense, Mr. Strange. I'm about to say I don't quite understand what's meant in by the word crystallised in any event in September 2012 in relation to the breaches.
Yes, and that has been a creature of both the it was a word that was used throughout the summary judgment hearing, and what it essentially means is by certainly no later than that date, they were, if they were latent, they had occurred. But I think when we look at 12, I agree with Mr. Montague-Smith. It's unlikely once we've gone through the earlier exercises that it won't be clear from that, but we will be sure to make that clear and perhaps think of a bit better drafting words than crystallised in any event.
Yes, well, I think you're bound to give particulars of any breach that you rely on that it is later in time,
Yes.
because of the question of, quote, continuing breach. If you say something is a continuing breach that continues throughout the period until 2018, then you need specifically to say so.
Yes.
And I'm rather inclined to think, obviously we know when the renunciation method took place, but I'm inclined to think that crystallised is rather a meaningless term in this context, when one's thinking about limitation.
Yes, and I think the reason there's been a specific date is obviously because of the standstill agreements and the limitation period. So if you're a claimant and you're saying, I think you have the point. My lord, on request. Yes.
What you were really saying that were still breaches as at that date, which would, on your view of the standstill agreements, mean that you're in time with your complaint. But if you are going to say they're continuing breaches, then they've got to be grappled with by both parties, and therefore you need to specify what the breaches are.
Yes.
Yes. Okay. Well, I think that's pretty clear. So that leaves request 13, does it?
Yes, and 13 I do have a slightly different view on. I agree in broad terms. I don't want to be quoted on it later because there'll be nuances that I'll wish to add. But Mr. Montague-Smith's summary of restitution, unjust enrichment from a liability point of view, I accept and agree with. But I don't see that characterization manifests in the request, because it seems to me what they're really saying is you say you put this sum in directly or indirectly, who contributed them, who received them, and how much were they. That seems to be an evidential request. In other words, they may run a point that no, these sums were put in by someone other than the claimants or other than on the claimant's behalf, and they were received by someone other than the defendants, and therefore the benefit wasn't what wasn't something or isn't something that could be subject to an unjust enrichment claim, and therefore a claim in relief for restitution. That seems to us certainly to be something that would be covered in the evidence, both disclosure and witness statements and the experts, and I don't see that they need need that information prior to then. If for some reason it's felt that they ought to have it before, then it really seems to be a provision of information as to dates and amounts of money that both parties are aware of, and that also could be put in an amended particulars of claim. But it does seem different from the others in the sense that it really is evidence about receipts of money by whom and from whom.
But is the answer to A in fact the same as the figures that would appear under B and paragraph 30? Yes.
I mean, we will, whether we're right or wrong will be a matter for you, but certainly we will be saying we put the money in, they were either directly or on our behalf. You, the defendants, received them, and the amount of each contribution relied upon is in cumulatively the amount that's sought by way of restitution.
There's an oddity here, isn't there? I mean, this might be put as a question of reliance damages as opposed to expectation damages. This is the money that we expended in order to do the feasibility studies and consultancy arrangements and discussions with builders and so on and so forth, design and all the rest of it in reliance upon the JVA agreements that we have simply wasted as a result of your breach of the agreement. But if you do that, of course, you've got a problem then with your expectation damages. But restitution, of course, is different in the sense that in the ordinary way, taking restitution in its most simplistic form, it would be something that went to the other party which they ought to hand back. I'm taking the simplest form of restitution. That's what restitute means. So I think there is an entitlement to the point. The question is, what's the most convenient point for this to be particularized in terms of loss and damage and in terms of the case on restitution. But I think what you're telling me is what I rather suspected, is that actually the figures in little a are going to be the same as the figures in little b, and it's an alternative way of putting the case, whether good or bad would have to be resolved in due course.
Yes.
Am I right about that?
Yes,
well,
I think you're right.
You probably what you need to do is to spell that out, so to speak. Mr. Montague Smith's point is it's a restitution case he needs to understand, and he doesn't seem too troubled by the fact that you haven't specified all the other damages under B, C, D, E, F, G, etc., etc., and some of them obviously are difficult to do.
Yes,
but I think it would help to clarify your case on damages as to whether you're claiming expectation damages and stroke or reliance damages, and to say how you put the case in relation to restitution, if there is a restitutionary case in addition. So,
yes.
Subject to anything Mr. Montague Smith wants to say, I would have thought that the order would be something of this kind, that the claimant particularizes the nature of the case it raises as to reliance damage, expectation damage, and restitution in relation to the heads claimed under paragraphs little a through to little whatever it is.
Yes, yes.
And that's what I'm knowing at this stage.
Well, at the end,
do you want to say something about that, Montague Smith, whether that he thinks that meets his requirements or whether he's dissatisfied with that?
I'm sorry, you're breaking up a little for me. It's probably at my end, but it sounds very sensible. It sounds like, in effect, Your Honour is suggesting that my friend replead, in effect, his quantum case and explain the legal basis and as to how it arises. The request only goes to A, But yes, I can fully see why it will make sense and shorten things, hopefully, to have a broader explanation.
I think one needs to know the nature of the case that's being put in relation to these heads, the exact details of which some of which will depend on expert evidence in any event, and probably one doesn't need to know the exact sums, but basically the way in which the case is put, and particularly if there's something unusual about the restitutionary claim, in terms of who's provided the money or where it's gone to or what it's been used for. But I anticipate that in truth it's just an alternative way of putting the case that's otherwise set out in B.
Yes, I see.
That I think is what needs to be clarified. And at some point you are going to have to particularize the damages, aren't you, Mr. Swain?
Oh yes, yes, certainly. There's no doubt that the information in request 13A, B, and C is something that will come, but from our perspective, it's the question of timing, and it would be a combination of disclosure, witness statements, and expert reports.
Do we need to provide then in the case management order that it's for a point at which you produce a schedule of damages?
Yes, I was thinking in 12, we have in paragraph 12 we have the real estate valuation loss of profits, and in 13 it's setting out its claim for damages by 30 September. It struck me that there we could put a schedule of loss in, and that I don't think we need to say it, but when we look at B, loss of profits in a real estate development, that would be in respect of all pleaded claims. So I don't think we need to put words restitutionary claims and loss of profits, but that should be clear that it's 12B is for all.
I think that makes sense. The new paragraph 13A, that at the same time as you file and serve your experts' reports, you file a schedule of loss and damage in respect of paragraph 30 of the particulars of claim.
Yes, yes, and that would leave, in effect, the answer to the current request coming in paragraph 13A of the directions, but we would give the what I would call the legal basis, the further clarification on the legal basis. That ought to come in the amended particulars of claim. That's probably the best place for it.
I'm sorry, Mr. Swange, I didn't quite catch that.
Sorry, I'm sure it's my fault. So in effect, the answer to request 13A, B, and C would come in the new paragraph 13A of the directions, and meanwhile in paragraph and in the amended particulars of claim, we would also add in what I would call is legal pleading as to the legal basis, clarified legal basis for our damages claims.
Yeah, well, that happens when you would expect probably a response. But that was maybe. What do you think about that, Mr. Montague-Smith?
Yes, I mean, in terms of a schedule, I think it's sensible and the timing is fine. In terms of the request and the clarification of the legal basis, it seems to me that it has to be clear that the essential facts which are being relied on need to be spelled out. So I hear what Your Honour says about 30A may simply be another way of putting 30B, but if there is a restitution claim, we do need to understand where that money is coming from, what the money is, and who it went to, because there will potentially be all kinds of legal arguments. One can imagine factual scenarios in which reflective loss type arguments arise, or all kinds of different things, which may or may not need different factual responses. So as long as the response to the request isn't watered down, then I do see the sense in having a schedule of loss at the date that you've mentioned.
Right. Well, I think, Mr. Swange, you need to say something about the general nature of the case that you're pursuing. It's probably a 2-paragraph job or something, but in response to the request in relation to paragraph 30, something along the lines of what I said a few moments ago, I think, is the answer. State the general nature of the case being made, as to restitution in paragraph 30A, including the nature of the sums referred to and the identity of the parties or parties involved in the payments concerned, something of that kind.
Yes. Understood.
So yeah, all right. Well, I think that deals with the particulars then. Thank you both very much. That then brings us to the more vexed subject of costs, does it?
It does.
You haven't, in fact, got, have you, the detailed breakdown from a cost draftsman that you were thinking of having or hoping to have by today, Mr. Strange? Is that right?
We haven't, and it's but I understand it's imminent. It's like in the next day or so. Now, if given that you've been burdened with this case from this day forward, my lord, one position we could take is if you would find that helpful, that can be served in draft on the defendants, and both parties can put some written submissions in. And if you want to hear from us orally, fine, but if you're content to deal with it on paper, we can do it that way. Or we can just deal with it today based on the material that you currently have.
Well, perhaps if I indicate the way I'm thinking.
Always helpful.
On the face of it, Mr. Strange, your bill is very large. I say no more until I've heard more from you. The basis upon which I make orders for interim payment is that self-evidently I only order that which I'm confident that you are necessarily going to recover. And on the face of it, I would certainly be looking at a 50% or perhaps a slightly higher percentage of a lesser figure that I am very confident you will recover. Whether or not a detailed bill of costs by a cost draftsman would help me very much, I don't really know without seeing it. I can form a view based on the hours spent and so on as to what I think the position would be. In a sense, it's a matter for you. If you want
Yes.
to apply to adjourn this application so that I can consider the matter with the benefit of a draftsman, a cost draftsman's bill, that's a matter for you. But otherwise, I think I'm supposed to deal with it today.
Understood, my lord. And can I
The only question is how much, isn't it?
Yes, and if I can just be clear, I'll put it in these terms, which hopefully are fair. Your provisional view is that the 50% is likely to be an amount less than that's currently claimed, because your job is to have some confidence as to the amounts that will be awarded on a detailed assessment. So really the issue for me to address today is, in broad strokes, why the costs were what they were. That's really what you want me to address you on.
Yeah, yes, I think that you've got to justify the size of the overall bill, and I know I'm a bit out of touch.
I wouldn't say that.
But I've seen very large bills in arbitration in particular. I'll tell you what my basic problem is, and that is simply that I always have this problem with the number of people who are involved.
Yes.
In the team, and therefore the number of hours spent.
Yes.
It's always
my
difficult
yes.
to work on documents as to what is really necessary. But when I looked at some of these figures, I was, to be frank, rather troubled by it. Mr. Lovett does make one or two points as to the number of partner days that are effectively accounted for in
Well, my lord, why don't I do this? Because
that's probably going to arise, just the same whether or not a cost draftsman still is in front of me or not. So it may very well be that the sensible thing for you to do is to address me on that.
Yes, well, perhaps I can do this then. No coincidence that the issues that I wanted to address you on with respect to cost was the number of team members, because that had been something raised, the amount of time spent, and also just a couple of points on the specific comparisons. So if I could, perhaps, my lord, if we could take up the schedules. The first one is at tab 18, and it's page 1285.
Yes.
And, my lord, if I could start on the first page, just so you have the cast of characters, if you will. So Mr. Ali is somebody who has been involved in this transaction almost from the inception and is responsible for dealing with the client. I'll save the blushes as to who I am. You know who I am. Ms. Walker is the solicitor in charge and solicitor of the record. Mr. Hess and Mr. Perkins were two associates who were involved at the time of the summary judgment. Ms. Wong was the paralegal who did most of the work and attended. The other two, Saxon and Fiers, have done very limited amounts, as with Magawa and Abdu, and we'll actually see in their time that they have very limited involvement. I mean, it's around $10,000 for those bottom two, and it's similar. So what you really have is you have an advocate, a partner, two associates, and then Mr. Ali, who's both an important source of facts, but also the client contact. Bearing in mind, my lord, that this is a $500 million case, and that a strikeout was obviously a seminal step, and it could have spelled the end of the matter. I would suggest that that's not an unreasonable size of team for a commercial dispute of this nature. And I do, without going into huge detail, your lordship's probably seen both the first instance judgment and the appeal judgment, but it's very easy when you're in the defendant's position, as they were, to take the 8 points. And if your lordship's not familiar with them, just by way of reference, they're summarized in the Court of Appeal judgment.
I've read the Court of Appeal judgment.
You've read the Court of Appeal. So, yeah. So you've seen the 8 grounds. It's very easy to make those points, rely on one document, and say there ought not to be a trial because it's all very simple. When you're in the claimant's position, you have to do two things. One, you have to say this case is not appropriate for summary judgment, strikeout, because there are contentious factual issues. But then to establish that, you have to show some of the contention and why a trial is needed. So that's a more significant task, and it does require reference to evidence and documents, and you have to present a chronology. I agree with what is said in the defendant's skeleton that usually an appeal is somewhat more simple and more narrow when you're looking at points of law. Here, though, the position was somewhat different, and importantly so, in that having lost the summary judgment on not only the legal points, in other words, this was a case that was suitable for summary judgment, the judge also, first instance judge, also made a number of factual conclusions in relation to things like fundamental breach, non-fundamental breach, when the breaches had taken place, and therefore when the limitations ran, and also in relation to affirming the breach. And so on the appeal, which was listed for 2 days and for which we had to save a $500 million case, we had to prepare ourselves for the silver bullet point, which is this case was never appropriate for summary judgment, but also the possibility that the court said, Well, we've looked at the judge's findings, and we need you to persuade us as to why he wasn't able to reach those findings on the material before him, because that was the second element of our appeal, and there were 5 specific points that we had to address there. So really the appeal had 2 limbs, and the second was the far more detailed orientated and difficult, given that we had all of the evidence below and then the transcripts. Now, in the event, we were fortunate that the Court of Appeal accepted our silver bullet position, and they accepted it very quickly during the course of the appeal, and that's what brought the appeal to a rapid end in our favour. But of course we didn't have the luxury of knowing that that was going to be the case when we stepped into the appeal, and we certainly had to prepare for it. And when I come to that schedule of costs, the main criticism there is Mr. Williams came in and spent a lot of time. Again, in a $500 million case where you are really in last chance saloon, and there is the possibility of having a very factually dense appeal where we're trying to persuade appellate judges to interfere with factual findings made by a first instance judge, I would respectfully submit that it's not unreasonable for leading counsel to have a junior, and for that junior to get into the detail of the case. And that's really where Mr. Williams is brought in. So when you look at points like the ones that were made, that have been made on the appeal, oh, there's 4 partners. Well, really, there's 1 partner in charge of the case, that's Ms. Walker. There's 2 people doing the advocacy, that's Mr. Williams and I. And then there's Mr. Ali, who is the client partner and also somebody who is very ingrained in the detail. Now, if we were in the commercial court and you were to see a leading counsel and a junior, and then a partner with carriage, and then another partner is the client partner, on a $500 million case for an appeal, I don't think anybody would squirm at that. Indeed, they would consider it quite normal. And when you look at the hours, both for the appeal but for the summary judgment, it's really that core team that's spending the majority of the time, with some help from paralegals and associates where appropriate. And if I could say, if you look at the second page, page 286 of the summary judgment application,
yeah,
and you look at attendance on others, there you have Mr. Ali. It's unsurprising as the client partner that he and Ms. Walker and Mr. Perkins are doing the vast majority of the attendance on others, both the adversaries and the client, whereas me as the advocate's doing very little. Then when you look at work on documents, really the nub of it is Mr. Perkins. There were a number of witness statements prepared for that. Ms. Walker, she had a statement in her own name. Me getting ready for drafting the skeleton and doing the hearing. And Mr. Ali helping me with the facts because he lived and breathed with them, and considering the 3 draft witness statements. Then you look at the attendance of the hearing, we've really only got 1 associate who was backing me up, Ms. Walker and Mr. Ali, and a paralegal. So that again, for a $500 million strikeout application is, I would say, fairly respectable. And then again, you look at the time that others have spent on work on documents. It's all pretty small beer once you get below Mr. Perkins. Indeed, you're looking at probably about $30,000 or $40,000. Now, my lord, the Court of Appeal skeleton. The Court of Appeal schedule of costs is at 294.
Yeah.
And again, they're looking at the cast of characters and the fairness, saying all that's happened is that Mr. Williams has stepped in as my junior. Miss Ravola has replaced Mr. Hess, and we still have Ms. Wong. The attendance on opponents, again, you would expect what you see there. No involvement from me as the advocate, and the majority of it is by Mr. Williams and Ms. Walker. Attendance on others. Unsurprisingly, Mr. Ali is dealing with the client, Ms. Walker with the adversary, and very little time from me or Mr. Williams. And then work on documents. Now, much is made of Mr. Williams spending 138 hours and Ms. Fulova, but they have had to get on top of, prepare appeal bundles, appeal documents for a $500 million seminal appeal that's listed for 2 days. And if you look at those in the round and you imagine that this was an appeal in England or any other jurisdiction, those would be expected. And then you'll see that Mr. Ali's hours and Ms. Walker's hours diminished considerably there for work on documents. But again, it's reasonable given that Mr. Ali lived and breathed it, and Ms. Walker's the solicitor with carriage, and obviously needs to consider not only the appeal documents, but also the skeleton and the other side skeletons when they come in. So the last point I want to make is this. In terms of comparisons, I've already said why at a macro level they're not comparable. The only other point I want to make on this is that the other comparison that's made, this is the one in relation to the disclosure, that theirs is 50,000 whilst ours is 450,000. And that's presented as an example of why our costs are unreasonable. If you go, please, my lord, to tab 14 of the CMC bundle, and it's I-208, page I-208, and it's paragraph 4. And there it said, please estimate the legal costs associated with standard production of documents. It said the legal costs of standard production are around 50,000, and in brackets, excluding costs already incurred undertaking document review for the purpose of preparing the defence.
Yeah.
And it said, oh, well, look, that's so much less. If you go to ours, yes, it's $450,000, but that includes all of the costs already incurred in looking at documents and preparing documents for the purposes of the strikeout, the particulars of claim, the reply, and the appeal. In other words, we've simply included all the time we've spent getting the documents ready, and we've included it in our estimate, whereas they haven't. Now, I'm not saying they're right and we're wrong, or vice versa. It's just an apples and oranges comparison. So for all those reasons, my lord, I don't suggest that it's cheap, and I don't suggest that all of those costs will be recovered on a detailed assessment. But when you break it down and look at it into the detail, yes, there are a number of names on the team sheet, but actually the contribution to 3 or 4 of those names is very small, both in terms of hours and cost. And then when you look at where the majority of the time has been spent, it's fairly and evenly and reasonably divided between those who are dealing with the client and managing the case, and those who are dealing with the presentation of the case. And saying things like 4 partners is a little misleading when 2 of those partners are the advocates and the other 2 are the day-to-day. So for all those reasons, my lord, the 50% of how much I say, I accept it shouldn't be the total amount, but I also say it shouldn't be a significant reduction. And I would respectfully suggest 50% of 75% would be a fair amount.
What does that work out at?
I knew you were going to ask me that, and I just grabbed my calculator.
Well, I've got 2 more questions before you ask for that one.
Well, someone will do that for me and message it to me while I handle your next 2 questions.
Indeed. My understanding from your letter of the 30th of November 2020
yes.
at I-293.
Yes.
1293, whatever it is
yes.
that in fact you have not charged for all of Mr. Ali's time.
Correct.
And indeed, if you look at the total bill of the appeal that's referred to there as $724,000 as opposed to the 890 odd that appears in the bill of costs at page 295.
Yes.
Is that right?
That's
I'm not
correct.
quite sure what you've taken out of Mr. Hardy's time and what remains in.
No, my understanding is that is an arbitrary deduction.
Right.
Rather than
so some of Mr. Hardy's time is in, but some is out. Is that right? And the same with Mr.
correct.
Walker.
Correct.
Okay. Now,
and
then go back to page 295, the Court of Appeal bill of costs.
Yes.
I'm ignoring Mr. Hardy's time on work on documents on the basis that that's probably out for the purposes of the bill that you're actually seeking recovery. But if you look then at Sarah Walker, yourself, and Mr. Williams, leaving aside Katerina Forova for a moment, that's 268 hours, which on a 10-hour day, and I don't know whether you work 16-hour days or less, but on a 10-hour day, which I regard as a fairly a good charging day for a solicitor in the ordinary way, that's 26 partner days. Now, if I was preparing for a Court of Appeal matter as a member of the bar years ago, I've got to do a skeleton argument in advance. I've got to get the case up again for a second time as the case comes up for hearing. But the documents are exactly the same as before. The evidence hasn't changed. We haven't had to go out and get new evidence and so on. I mean, I just find that sort of time, partner time, as being an incredible amount. If I was preparing for something in the Court of Appeal, doing a skeleton, I might take as much as a couple of days to prepare the skeleton. I might take a couple of days to prepare for the Court of Appeal. But I just don't see how you get to 26 partner days. Now, I may be very out of touch and naive on this, but can you help me on that?
Yes, I certainly can, my lord. So let's take Mr. Williams first, 138 hours. He had not engaged in this case at first instance. We effectively did it without a junior. So he steps into it, and so assume of that 138 hours of Mr. Williams that you could spread that across both applications, because he has to get up to speed with everything that was done at first instance. Otherwise, he's not much good to me as a junior for the appeal. So that
he's got to read the document. He's got to read the judgment.
He's got to read either 5 or 6 witness statements. He's got to read all of the transcripts. He's got to read all of the skeletons. He's got to read the judgments, and then he's got to prepare the appeal documents, first drafts of all of the appeal documents. So that's the grounds of appeal, the application for appeal, so on and so forth. And he's got to deal with, and assist Ms. Walker with all of the back and forth between the parties as to the appeal, getting the other side's appeal documents in, responding to those, and getting the appeal listed. So he's doing a number of things, including getting into the case for the first time. And if you take it on sort of a 50-hour week, he's done less than 2.5 weeks' work over a period of about 4.5, 5 months on this case, which I can certainly speak from my own experience is pretty reasonable. I don't see any issue with that. You then, and when I look at myself, I mean, the way you just described it, my lord, I agree. There's getting back up to speed. There's looking at the appeal documents. There's doing a skeleton. And then there's getting ready for a 2-day hearing before a pretty eminent Court of Appeal on a pretty contentious case where you may have to go through a number of factual findings and explain to the Court of Appeal why the first instance judge got it wrong. And you're doing it virtually where you don't know what documents and how the Court of Appeals are organized, so you have to get on top of the electronic bundles and know them backwards. And so those, if that's 2 weeks' work spread over 3.5 months and including the prep, that's fine. Now, Ms. Walker, she's the solicitor of the record. She doesn't have to do the heavy lifting in terms of the drafting of the appeal documents, and she doesn't have to do the heavy lifting for preparation for the appeal. But what she certainly has to do is to sign off on a lot of those documents, read them, be familiar with them. She is responsible for dealing with the other side skeleton, reading it, feeding into me and Mr. Williams about what she thinks and what points we need to focus on. And so over a period of about 4.5, 5 months, she spent 40 hours on documents. When you think about the documents going from all of the appeal documents, which is 6, and the skeletons, and then the hearing bundles, 40 hours is actually pretty insignificant over that length of time. So what I would say, my lord, is when you're looking at a big complicated case on appeal, where the appeal is not a normal appeal but an abnormal appeal because you may have to entertain all of the factual issues, it's spread over a period of 5 months, and the appeal is done before 3 judges in different places in the middle of a pandemic, electronically, where there's little room for error because a $500 million claim may disappear. That's a very significant amount of work. And when you think about it, other than dealing with others, work on documents is absolutely everything. Letters, grounds, pleadings, bundles, so on and so forth. So I wish these things could be done quicker and they took less time, but unfortunately that's how long they take. And the only other thing I would say, my lord, is that those numbers are significant, but they are in US dollars. And I can only tell you that in my last appearance before the Court of Appeal a couple of weeks ago, my adversary's brief fee for a one-day hearing was £110,000, which is around $150,000, $160,000. So that's the kind of numbers that we say are reasonable to be expected, given the points that I've made, and given particularly that Mr. Williams is basically saddling both applications because he had to get on top of them. And the only real difference is that he didn't attend the first instance hearing, so you can take that off, and he didn't have to draft the witness statements. But otherwise, in terms of the massive detail, and there was a very significant chronology of documents, he did have to. So I don't know if that helps you, my lord, in sort of further understanding, but that's the gist of it.
Yes, thank you. Well, I can well understand now you wouldn't want to appear before the ex-Chief Justice of Australia without knowing the documents back to front, particularly when he's got Roger Giles alongside him, as well as, of course, as the Chief Justice here. Yes, all right.
Yes,
well,
and
let me hear what...
Well,
your figure is about 483,000, isn't it?
Yes, exactly. And my lord, I'll just say this, as you know.
I can tell you this, Mr. Strange, that having looked at this beforehand, I come out with a figure of $450,000. So on that basis, we're not very far apart. But let me hear what Mr. Montague-Smith has to say.
Thank you, my lord.
Thank you, Your Honour. We've set out our position fairly fully, but if I can just give you the headlines. I think that there is a general intake of breath just looking at the figures. I don't say and I don't accept that those are in the ordinary run for an immediate judgment hearing of 1 day and then for an appeal, which was, yes, listed for 2 days, but that was at the insistence of the claimants, with the resistance of the defendants, and in fact it took much less than a day to get to the end of it. And I think you're looking at, and Your Honour has the point, that the amount actually spent on the appeal was $890,000. Now, we understand that some of that isn't claimed, and we understand that most of what is not claimed relates to Mr. Ali's costs, but that is not entirely clear. So we understand that about 165,000 has just been somewhat arbitrarily lopped off the costs bill, no doubt because it's just acknowledged that takes it well over the line. but we've got no insight into how that's happened, other than this potentially. It seems Mr. Ali's fees being reduced, but only on the appeal, not in relation to the immediate judgment hearing. And just to put it in context, the numbers. So the defendants advanced, provided obviously a cost schedule for the hearing below, and gave an estimate of costs of the appeal as well. And those costs were 227,000 for the hearing below, approximately. The exact numbers are in my skeleton. That's against 565,000 for the claimants. And then in relation to the appeal, the costs were 245,000 estimated, and that's against this figure of 890 or 725,000, depending on which you take. So we're talking about well under a half at first instance, and on the case of the appeal, about a third. And in response to those sums, the claimant came back and said that the costs were, quote, excessive and overinflated. Your Honor, can I just check that you still have me, because I've lost the picture of you?
Yeah, no, I can hear you perfectly well, thank you.
Thank you, good. I just thought I'd check, given what's happened. And so we have a number of observations, and I've set them out in our skeleton. Firstly, we have some observations about the rates that are used. There are, as Your Honour knows, guideline rates, and the various ranges that were applied. But at their height, they get to about 210% of the guidelines. That is a feature, we say, that needs to be taken into account. You've already got the point, Your Honour, that there were 13 different fee earners, and there appears to be quite a substantial change of the team from first instance to the appeal, and that includes, as we've heard, 4 partners by the time of the appeal, doing what appears to be a large chunk of the work. In relation to Mr. Ali, he's not a litigator, so he's the corporate partner who was involved in the substantive negotiations. Now, one might see that he might have some involvement in relation to the case, but in respect of an application for immediate judgment, it's very difficult to see what his role should really be. And despite that, a total of, just to get the scale of this, $246,000 was spent on his involvement, not on the claim, but on the application and the appeal. It may be that only about 85,000 of that is claimed. It's still a very substantial sum. It just seems to pale into insignificance, but it's hard to know precisely what is claimed in relation to him. But that gives a sense of what is going on, and we're told quite a lot of that is partner-facing. Now, client-facing. Now, if a party wants to sit in a room with its lawyers for days on end and talk about the case and talk about the applications, that's up to the party. But that is not reasonable expenditure in relation to what is a fairly narrow application for strikeout. If we look at the numbers, if you go to page 285, we're looking just first at the numbers below, and just to draw out 1 or 2 points. I make it at the hearing below work done on documents, which appears at 286. I add that up to about $346,000. Now, just in relation to that, the evidence below, because this is the defendant's application, the evidence below from the claimants consisted of 3 witness statements. All of them were said by the Court of Appeal to be more by way of argument than by way of evidence. And we've referred to the paragraphs of the judgment. I don't think we need to go to it, but it's paragraphs 29 to 31 of the Court of Appeal's judgment. And the other point I make in relation to that is, insofar as the statements are factual, there's obviously a significant overlap between their preparation and just costs of the case. So that's also brought into relief by something that my learned friend said. So he says, for example, in relation to the cost of preparing documents for the case, the total cost would be $450,000. That's reasonable, he says, because that cost incorporates money that's been spent on the application. So he's conceding, asserting that the costs that are in this schedule include costs which are attributable, in effect, to preparation of the case for trial. It's not possible to pick that all apart on the basis of the precisely on the basis of the schedule that we have, but there's clearly going to be an overlap. And in relation to solicitor witness statements, there's an argument we would say that the whole of that statement was inadmissible. Your Honour's aware of the practice direction about this, and one can take it with a pinch of salt in a sense, but the practice direction says generally it's not for solicitors to give evidence, and where they do, it ought to be confined to exhibiting documents, or alternatively it'll be treated, if it's statements of opinion, as in effect submission. But if it's evidence, it's not admissible. If it's submission, well then it overlaps with the advocacy fees. So we would say in relation to that, there's quite substantial sums there. Mostly we understand sums incurred in relation to Ms. Walker and her preparation of witness evidence, because it was her statement, which we just say there would be no award in relation to them. There's no brief fee on this, but really what you would expect is an exhibit in the evidence containing the relevant documents. You would then have the pleadings themselves, and then it's all going to be a matter of submission. And so in terms of the actual documents that really were required to be got on top of in relation to this, it's relatively limited, we say. The total fees for advocacy for the one-day hearing below, we understand, were $93,000 US dollars. For a one-day hearing in this court, certainly, we would say that is a very heavy fee. I think my learned friend has 2 years on me in terms of experience, and it may be in 2 years' time I'll be able to command those sorts of fees. I doubt it very much. And frankly, if one is doing the exercise that my own friend suggests, which is compare this if you'd instructed counsel, that is an extremely heavy fee for a one-day hearing. But generally, we say one looks at 565,000 for that sort of hearing, and it is frankly extravagant. But then the appeal itself is where it gets remarkable. If you spent that much time and money at first instance, that there really can be no justification for approaching that sort of money on an appeal. It ought to be less, and we say significantly less. And you've heard that Mr. Williams was added to the advocacy team. And I mean, I have to say, I've never seen this, but I mean, between Mr. Williams and Mr. Sprange, in terms of advocacy, the total bill was $381,000 US dollars for a 1 to 2 day hearing. And Mr. Williams has 12 years experience, and his bill was $231,000, whereas Mr. Sprange charged $150,000. Now, he says, well, it's not unusual to have a silk and a junior on an application like this. I think they're probably right that this could have justified a silk and a junior, but I have certainly never seen a junior try to charge £230,000 for a 2 day hearing. That is astronomical billing, any award at this stage really needs to take that into account. I don't accept that $150,000 is the sort of fee you would see for a senior counsel in relation to this either. That is a very heavy fee for running essentially the same points as were run below. My friend said, oh, well, that the issues changed. I don't accept that. That there was a 17-page grounds of appeal filed by the claimants in relation to the decision below. None of those grounds, as far as I can see, asserted that the court had decided anything that wasn't properly put before it by the parties. It doesn't look to me, at least, like the issues expanded on appeal. And as you have heard, ultimately the Court of Appeal decided this on a narrow threshold issue, which was that there's just too much factual dispute here for this to be determined at this stage. So in terms of preparation, you would expect an appellant's notice, grounds of appeal, and then skeleton arguments, and then preparation for the hearing and attendance. And a sum of $381,000 for that is, I would say, truly extraordinary. The other point is that if all of that is being handled by Mr. Sprange and Mr. Williams, well, it's really hard to know where you find all those other partner hours, because on documents alone for the appeal, you've got spending of $591,000. That incorporates Mr. Williams and Mr. Sprange's fees, but so there are hundreds of thousands of dollars being spent on time by other fee earners in relation to presumably these documents. It's unclear what other documents there would be than the formal documents required for the appeal. And in total, you've got this, Your Honour, but there were 540 lawyer hours spent on documents. And that includes not just Mr. Strange, not just Mr. Williams, but for example, Ms. Frolova is charging $132,000 for work on documents. And that is a healthy leader junior brief fee right there for doing all of it. Ms. Walker charged another $64,000 on documents for the appeal. We're not talking about creating any more evidence here. We're just dealing with these pleadings in effect for the appeal. And it's said by my own friend, well, that sum for documents includes, for example, everything, letters. But there is then a further $177,000 on attendance on others, which one would expect to include the letters and things like that. So it can't quite be right that it includes absolutely everything. Otherwise, what is that 177,000 to do with? I worked it out at being on documents about 3 months. It may be slightly less than that if one adopts 10 hours a day. But it's got to be recalled that that amount is being spent on top of $345,000 spent on documents below. So you've got a total amount over the course of these 2 hearings on documents alone of getting towards $950,000. And then there's all these other...
Figure, Mr. Montague-Smith, what was the figure on documents at the first instance stage? There's not a total in the
yes,
page 36.
I made it 345,000.
Right. It's 360 hours of various people's time, isn't it?
About that, yeah. At a very healthy rate. Again, I mean, if we're comparing it to work, particularly when we're dealing with an appeal, if we're comparing it to work that might be done by counsel, you're talking about rates that range from $1,350 an hour to $1,500 or $1,600 an hour. So you're talking about 12. Sorry.
The rate seems to have gone down, according to page 294.
Yes, it looks like there's a reduction. It looks like a 10% reduction across the board.
Wow.
But it's hard to know.
How unusual. You usually tend to go up. Anyway, there we are.
That might reflect the eye-watering sums that we're dealing with. But it's impossible to know where that dividing line falls. Perhaps one could figure it out using a calculation from the rate, but we don't know how much of it was charged. So some of it was charged at $1,615 an hour, which again is a very you'd stock your entire team with quite senior QCs for those sorts of sums. But ultimately, and then on top of that, you've got this whole category. So we've got, in terms of the appeal, 74,000, almost 74,000 and a bit spent on attendance on others. Opponents, that is. Attendance on others on the appeal is $177,000. And it's assumed that the attendance on others is where the client contact is mostly based. And below that number was about 75,000. So you've got about $250,000 being spent on what looks like, reading between the lines, a lot of conferences with the party about these issues. It's not easy to know, quite frankly. So the question for Your Honour is what to do with all of this at this stage. It's obviously up to the claimants if they want to spend this kind of money on these sorts of applications, and if they want to continue to do so. But we do say that it is important. We don't have cost budgeting in this court. Some people think that's a good thing, but there is a benefit to cost budgeting, which is that it lets people know what they're likely to get back, what they will get back at the end of the case. There is a benefit, it seems to me, at this stage of Your Honour laying down something or a marker about what is and is not likely to be a reasonable approach going forward. We've heard the answer in relation to the 450,000 spent on documents, but as I say, in relation to that, the effect of that seems to be that quite a lot of the cost of the case are being thrown in with the cost of the application. So on one view, Your Honour might find you're just not confident that the schedules really reflect reasonable spending. On the other hand, you might start looking for a starting point, and if you are going to take that approach, my suggestion would be that you use the defendant's figures as a starting point. That's a legitimate approach. My friend says it's not in his pleadings, but that's not correct. You could start with the defendant's figures, bearing in mind that the claimant had already said that they were excessive, and work from there to find a baseline. For what you are accepting is a number which they are not going to get less than on assessment, and give them some proportion of what the defendants spent below. If that is the approach that you're going to adopt, if you're going to take the view that you need to make some sort of award at this stage, then that is what I would urge you to do, on the basis that there are so many unknowns about what is properly attributed, and we can see there's significant excessive spending, not just globally, but also when we look in a little bit more detail at the spending. In my submission, it's simply not safe to work from these sorts of numbers.
Well, Mr. Montague-Smith, do you think you can do better than the figure of 450,000 that I had indicated was my preliminary view, having looked at the papers earlier?
Yes.
If I took 50% of Gibson Dunn's figures, I'd be only on 236, wouldn't I?
No, I see that. But if one was to take 75%, for example, of those figures, you would get to a sum of $354,000. So if you were to say, and those are figures which, as I say, the claimants have already criticised as being excessive and overinflated. 75%
well,
of
that's knee-jerk reaction, no doubt.
Well, perhaps, but they said it in the knowledge of their own costs.
Had they served a schedule by that stage?
I don't think so.
No, I suspect not.
So they hadn't. Oh, they had. Yeah, they had apparently. Anyway, but in any event,
so those costs were excessive in the face of their own schedule that showed. What did it show? So
565,000 for below.
500 and something, yes.
And then 700 and 880 on appeal. I mean, there's always a tendency to sort of say, oh well, these costs have been incurred, but it just is in this case. There are so many things which indicate that there's just been no cost control whatsoever, that Your Honour runs the risk of granting an award of a certain amount which will exceed what they get back at the end. And the aim is to be conservative at this stage. That's what the authorities tell us. And so in that context, it seems to me that the better approach is to give a proportion, perhaps a more significant proportion than we would have got if we were in the position of asking for an interim payment, but a proportion of what those fees actually were.
Yes, all right. Thank you, Mr. Strange.
Yes, just a couple of quick things. And I need to put Mr. Ali in context. The claimant's shareholders are Arabic speakers and have worked with Mr. Ali for a number of years. I have no hope, and with respect to Ms. Walker, she has the same level of no hope, of articulating complicated legal issues and procedure to them without Mr. Ali. He is essential to what the claimants do by bringing this case. And so I think the character attack on him as, oh, just the corporate guy from Mr. Montague-Smith is a little unfair. It is reasonable for a client to have an Arabic-speaking, as an Arabic speaker, to have an Arabic-speaking partner assist them with understanding the case. It's no good if Mr. Ali sits there and says, well, I haven't read anything, so I can't tell you anything. So obviously he needs to read documents and he needs to be engaged with the case. and that is reasonable. And it is also reasonable in circumstances where we seem to forget this. The defendants bought a strikeout application that was that should never have been bought and was soundly thrown out on appeal on a silver bullet point. Having adopted that tactic and taken it, one of the consequences they suffer is having to pay for it. And it's unfair to say that my clients, who benefit greatly from Mr. Ali's involvement, can't recover at least some of the costs of having him involved and then properly understanding the case and articulating the case to him so it can be articulated to those who need to present it. Second specific point I want to raise is that it's said that Mr. Williams has charged an enormous brief fee. Again, I'm afraid that, and I'm sure it's not an example of any prejudice or anything like that, but it's Mr. Montague-Smith failing to understand the role of an in-house advocate, because he's not one and he doesn't do it day to day. What Mr. Williams does, and it actually turns out to be cheaper because he does two roles, is he's doing with Ms. Walker day-to-day solicitor work. So if letters need to be written, if there's communications with the other side regarding particular issues, if there's arrangements that need to be made for the hearing, he's involved in those. He's also then helping me with appeal documents, skeletons, and getting ready for the hearing. So it's not fair to say that all of the numbers that you see from Mr. Williams are a brief fee. They're simply not. They're a conglomeration of solicitor work and then work that he's done as an advocate to assist. The third point I want to make is this, that when we talk about work done on documents, one of the evils of making submissions on a summary basis about working on documents is that the person suggesting that the costs are too high tries to narrow down the nature of that work and say, oh, it was 4 documents and they spent 500 hours. It is simply not that simple when you are a solicitor's firm running a case day to day. It is pretty much every document, including emails, letters, appeal documents, skeletons, all of the documents that make up the life of an appeal from day one till the end. And it is also, when you see for an advocate 90 hours, that includes preparing for the hearing. When you're working on documents, that may be reading one of the 47 authorities that the other side have put in, and so you need to get on top of them and understand them. So working on documents is an incredibly broad aspect of work, and it can't be narrowed down in the way that's been suggested. Finally, I just want to say this, in terms of overlap, there is no overlap, and if it sounded like I was saying that there is an overlap between these costs and preparation for the case in general, that's incorrect. I certainly didn't make that concession. It is true that by having a strikeout and then an appeal, we've certainly got a clear look into the costs. Sorry, the issues that will crop up at the trial. But as we've seen from for today's purposes, cases evolve and develop, and you don't remember everything that you remembered when you prepared for a summary judgment application. And a witness statement that you prepare for trial will be different from the one that was prepared before. And so that, we say, is something that you can put aside and you don't need to take into consideration for the purposes of considering this. So in summary, I say that the range is between my 50% and 75%, and the number that your lordship came up with, which I think is 450 versus 486.
Yes, thank you.
Oh, my lord, I forgot one thing. I'm sorry, and I've just got a message from the very reasonably priced Mr. Williams. In terms of the rates, we're actually cheaper than the defendant solicitors at present. So, for example, Mr. Lovett, the lead partner of Gibson Dunn, is somewhat more expensive than all of us, and some $100 more expensive than Mr. Ali. The two lead associates at $1,075 and $995, considerably more expensive than Ms. Frolova. So insofar as rates, we would ask you to ignore the submissions you've heard on that, because we're slightly cheaper than the defendants, and so we must be reasonably priced on that matrix.
Thank you. The Court of Appeal ordered payment of the costs of the appeal and the application to be made by the defendant, which had succeeded at first instance. The defendant, having won at first instance at a hearing for a strikeout or summary judgment, which lasted a day, claimed costs of $227,000 approximately. The claimant said that was excessive, but having won on appeal, the claimant now seeks costs of $564,000 approximately for that self-same application and hearing. The defendant, the claimant also seeks costs of $725,000 approximately on the costs of the appeal, having incurred, it appears, some $890,000, but slicing a certain amount off for the purpose of the claim. The defendant's comparable costs at $245,000. So on the one hand, we have some $472,000 costs incurred by the defendant, as compared with the total of the two figures I've already mentioned for the claimant. That disparity is huge. The claimant's costs are almost 3 times as much as those of the defendants. The ordinary rule, in accordance with PD 5 of 2014, is that the court would grant 50% of the claimed costs as an interim payment, pending detailed assessment, with the proviso, open quote, unless the court sees fit to order otherwise, close quote. The essential basis for making an order for payment of costs on an interim basis is the confidence of the court that at least that amount will be recovered on a detailed assessment. Here there are problems about confidence. I have examined the bills of costs submitted by the claimants and find it difficult to see how the extensive partner and associate time can be justified, particularly in relation to the costs of the appeal, where the material is essentially the same as that before the judge at first instance, with, of course, the addition of the first instance judgment. There was here no suggestion that additional evidence had been permitted and put before the Court of Appeal. So the starting point here does not seem to me to be appropriate. The Court does see fit to depart from the usual starting point of 50% of the cost claimed, because, in my judgment, the figures claimed look to be so large and difficult to justify. It's not right, self-evidently, simply to look at the defendant's cost figure and treat that as an appropriate measure. But the claimant's approach of using a team of as many as 13 different people on the claim at first instance and Court of Appeal when seen together, with some 3 or 4 throughout and others rotating, does seem to be excessive. It leads to exorbitant fees, which, in my judgment, are unlikely to be recoverable, even if acceptable to the claimant. Gibson Dunn, for the defendants, used a three-man team throughout, in essence, with the legwork being done by the more junior member of the team in what was obviously a much more economic approach. Of necessity, I have to adopt a broad brush approach when dealing with matters of this kind, although I have looked at the bills in some detail, in fact in more detail than will appear from the terms of this ruling. It will, of course, be a matter for detailed assessment at the end of the day, absent some agreement. But to my mind, 136 hours of partner time on documents at first instance, and 360 hours all told at first instance, spread across 10 different people, and 268 hours of partner time on documents at the appeal stage is not just over egging the pudding. In fact, at the appeal stage, total work on documents is some 359 hours by the various individuals concerned. I confess to finding that incredible. If one works out just how much time that is on a daily basis, even taking 10 hours a day as an appropriate period for each day's work, the sum which emerges is mind-boggling. I need not, I think, go any further into detail in relation to the figures for work done in attendance on opponents and attendance on others. What I have said is enough to show the large figures involved. I can only award that which I am confident with certainty will be recovered at the end of the day. I do not consider that the claimants would recover 1.289 million or anything like it on a detailed assessment. Even if Gibson Dunn's costs of 472,000 approximately are considered as parsimonious, and I doubt that Mr. Lovett is known for undercharging, a figure of the order of 800,000 might be seen as the outlying limit of what might be recovered in this case by the claimant. If I adopt that as a basic approach, the question is then whether I simply apply the 50% figure to that or allow something a little more. I have come to the conclusion that I should allow something a little more, simply on the basis that I think I can be confident that the claimants will recover that. The figure, therefore, that emerges from this broad brush approach is one of $430,000, and that is the figure that I award by way of an interim payment. So 430,000 it is.
Thank you, Anna.
Thank
I
you.
think all that leaves is the cost of the applications themselves. There's obviously three parts to this hearing. The case management parts, the request for information parts, and the interim payment on account of costs parts. My suggestion is that there ought also to be a costs order in respect of the proposed amendment to the statement of case. So those are the issues. In that, insofar as the response will take the form of amending pleadings, the normal rule would be that should have been done in the first place, and so the additional cost of doing so should be borne. The cost of an occasion by such an amendment should be borne by the claimant. So my proposal for cost orders for today would be to make discrete cost order in favour of the defendants in relation to the RFI, make no order as to costs on the application for an interim payment of the cost of the appeal and the application, and make the discrete cost order in relation to the particularisation of the pleading, and then costs in the case for everything else.
Mr. Montague-Smith, you've never offered any sum at all in relation to the interim payment, have you?
I think that's right in relation to the interim payment. There is, if I can put it this way, there is an offer in relation to the global final sum, and which obviously could affect, depending on what that outcome is, the cost consequences in relation to this application. But the basic point that the reason I was taking that position in relation to the interim payment. Sorry,
Mr. Montague-Smith, is that an open offer, so to speak? I mean, is there any reason why I shouldn't know what the offer was that you made in relation to the detailed assessment, so to speak, of costs, or anybody else who's actually has to do the assessment? Is it a figure that will be made known to them?
I think strictly you cannot be made known. It cannot be made known to you strictly at this stage. I imagine that you have the power to order us to disclose it to you. You will not be doing the detailed assessment, and that's the point that you're making.
Well, I certainly won't be doing the detailed assessment if I have anything to do with it.
Well, quite.
Afraid it would fall to the very able registrar or assistant registrar, probably the assistant registrar, to do.
Yes.
I suspect probably listening in.
Yes, quite.
Would that be a problem for her to know before she did the detailed assessment?
Strictly, I think it probably would, wouldn't it? It's a without. I mean, unless my clients are willing to waive, and everybody's willing to waive without prejudice privilege in relation to that offer, then I think that it's going to be a problem.
But the point is this, Mr. Montague-Smith, on the face of it, your clients have made no offer on an interim basis for an interim payment, and it seems to me on the face of that you ought to bear the cost of the application for an interim payment. I'm expressing a view here so that you can both comment on it. On
Yes.
the face of it, you've won on the request for information, and you ought to have the cost of that. The case management conference is obviously neutral, so it comes out pretty much all square.
Well, I see that. I mean, I think the comment that I would make in relation to the interim payment application is that the points that we have taken and the money that's been spent has all been in discussion of the kind of points that Your Honour has effectively accepted, which is the excessive number of hours and the details. So we have engaged on the quantum, and it's right that there's no offer in relation to the application, but nevertheless, ultimately what they got was about a third rather than the 50% that they were seeking, which was $650,000 US. So what I would suggest is that the outcome is one thing, but in terms of the issues that we've been dealing with, it's pretty much on as even, or perhaps slightly in favour of the defendants in terms of what we've actually been arguing about. And so on that's why I say no order as to cost would be the appropriate order in relation to that. But that's the position. It is complicated by the offer that's in the background, which could affect things.
The other way of dealing with it would be to reserve the costs and make them or make them cost in the detailed assessment. Because if there's an offer that is in the end going to impact on the cost of assessment,
Yes, I can see that.
this could follow on.
Yes, and
and there's a certain logic to that.
That makes all kinds of sense, and I think that's absolutely right, and I should have thought of that.
Mr. Sprague, well, it may or may not be a attractive course to you, but on the face of it, it appears to me logical that if there's an offer being made in relation to the detailed assessment, what matters at the end of the day is not the figure I've come to, but the figure that the detailed assessor comes to as compared with the offer that's been made. What do you have to say about that?
I do see it, unsurprisingly, from a different perspective. Today is the question of whether there ought to have been an interim payment or not. Their case,
I think it's always been accepted there would be an interim payment. I don't think they've ever argued against that. It's just they've never put forward a figure.
Oh, I think they have. I mean, Mr. Montague Smith said it, and it's in their skeleton. At present, the court may well take the view that it's simply impossible to get a clear view on what Hexagon will be entitled to recover on assessment. I mean, they've never, as you've alluded to, they have never made an offer. There's never been. You weren't presented with two competing numbers and asked to decide the two of them because their number was zero. And what you have decided today is that it's not zero, it's $430,000, and that is an issue that is now over and done with, and we have prevailed. We sought an interim payment. Our starting point was 50%. Their starting point was zero. So we have been largely successful. I don't see how a cost judge deciding what the ultimate amount should be can or ought to affect your determination of whether an interim payment of X or Y in our favour should be dealt with from a cost perspective. It seems to me we're here, it's been litigated, you've declared the position, and costs follow the event. And I don't see how the cost judge determination on a detailed assessment can affect that. And it's certainly the case that if we hadn't bought this application and we hadn't incurred the costs, we wouldn't have got an interim payment, and we would have had to wait for the detailed assessment. We've had to bring this application to get that interim payment of $430,000. So I certainly say you should assess them today, and you should do it on a summary assessment basis. And that's quite easy because on this one, the parties are fairly close. I think theirs was just on 40,000 and ours is just on 53,000. So that's a small difference. So we say they should be somewhere.
And is that in relation to the total cost of today, or is that in relation to one application or the other?
You do not have a summary of costs from the defendant on their RFA. So that is as regards the interim payment application.
Sorry, no, that's not correct. That's not correct.
The 53,000 figure, Mr. Swain, that I've got in front of me on a cost schedule from you, is that for the whole of everything that's taken place today, or is that in relation to one aspect only?
They're only for the interim costs application.
All right.
I should clarify. My learner friend is not correct when he says that my cost schedule is directed at that. It's not. My cost schedule is directed at the RFI.
I don't think I've got a cost schedule from you, have I?
Ah, I thought you had.
Well, I may have, but tell me where it is.
Oh, it won't be in the bundle because it came afterwards, I think, unless I'm getting I'm getting messages saying the court's confirmed that it was sent to you at some stage.
For my part, I certainly haven't seen a cost schedule from the defendants for the RFA.
Well, let me just
there's only one cost schedule. Have you seen? Sorry, someone's going to try and get you another copy. Then circulate it. I imagine.
Well, let me just check my emails here.
Yeah, there's no cost schedule on the interim payment application. I think that's where my learned friends at cross purposes with me. The defendants have not filed a cost schedule in relation to that.
So, right, I see.
Well, page 2, the description. Interim
Just
payment.
bear with me a moment, Mr. Strange, while I try and find.
Yeah, that might be the error. I understand that's an error. I see that, Mr. Strange.
I take that as an apology and I accept it.
Well, I'm not sure what you've apologised for, Mr. Norton. What have you got wrong?
I'm apologising. I'm correct that the cost schedule is in relation to the RFI. That is correct.
Right.
I'll be corrected by my solicitors if that's wrong, but that is correct. What is wrong, as I understand, I think, and again I'll be corrected, is that the reference to preparation of the interim payment application. So because it wasn't an interim payment application, it was an application for a request for further information. That's the only application that the defendants made, the application for the RFI. So it's simply a wrong wording. So I apologise for that, but I'm correct that is what the statement of costs is for.
Okay, I've just found it. It was sent to me yesterday. Yes, I see.
I can help you with the figures if you'd like, Your Honour, but perhaps we haven't got there yet.
Yes, no, I've just printed it off. So yes, you're 39,000 and a bit for your RFI application.
Correct. There's a little bit of what's happened is my fee for today has been apportioned, and so that is why the disbursements are what they are. That incorporates the part of my brief fee that we've apportioned in respect of the RFI, and then a little bit of help in relation to the application itself. I believe that comes out of about £15,000, but I might be wrong.
Oh, I see. Under the you're an expense or disbursement, is what you're telling me.
Yes, effectively, I am that.
Oh.
So there was a composite fee agreed for everything, which has been then apportioned effectively one third to everything, and so that's where you get the 15,000 from. You were, however, right that I did not draft the request for further information, but I did assist in the application.
Right. I'm going to take a blunt instrument for this, and I'm simply going to say that the cost of all of this are going to be cost in the case.
Does that follow also in relation to the amendment of the pleadings, though? That's the only question that I have, because normally, if one pleads one's case and then has to amend.
It's only an amendment because Mr. Strange thinks it's convenient to do it that way rather than simply answer the particulars. So I'm effectively treating today as being all square between the parties and just saying the right order should be cost in the case.
Understood.
Then the question of detailed assessment will proceed on its own basis, and the offer made in respect of that will stand or fall so far as that is concerned.
Understood.
And the assistant registrar will have to work out what to do about that. All right. Can you liaise and agree an order that covers everything, the case management issues, the RFI issues, and the interim cost issues, and lastly the cost in the case point that I've just determined. Agree that, and if you're agreed, then you can simply submit it to the court, and the court will issue it.
Thank you, Your Honour.
Absolutely, we will.
All right. I just need to make a note of the date. What was the date we said for the potential CMC? The 8th of July, was it?
8th of July.
Yeah.
And then
Right.
the trial was 3 weeks starting on the 6th of February.
3 weeks, 6th Feb. All right. Well, again, you need just to confirm those with the court that that's all right by the court. And they're listening in, no doubt, but it'd be best to have that confirmed in email so that there's no room for any confusion.
Yes. Does Your Honour have in mind a date for the amended particulars? Just, I don't think we covered that off.
No, we haven't.
No,
when would you like to produce that?
I was going to say 21 days in our draft order that we'd send to the defendants.
I think we'd rather have it in 14 days. But I think we'd rather have it in 14, but I mean, only in Your Honour's hands. It's simply that we start to get close up to documents at that point.
It's not an insignificant amount.
Today's a Monday, so I don't know which days of the week you're working, which days you aren't, but if we say by close of play Friday of sort of 17, 18 days hence, whatever it is.
Yes, okay.
Would that be
So close of business on Friday, the
12th of
I
March?
don't know what date in March it will be. Yeah, whatever date in March it is, 17 days ahead or 18 days ahead.
Yes,
Yes,
that would be the
all right.
19th. The
12th of March.
12th of March.
12th of March.
Sounds right.
Good.
Sounds right. Very good. All right.
Okay.
Well, thank you both very much. And,
Thank you.
I shall no doubt see you and hear from you in due course, but perhaps really in person by the time we get to July, but who knows?
Yes,
Let's hope so.
Today is one of the worst experiences I've had on these platforms. They do vary a bit, but I often seem to have more problems with Dubai than I do with other parts of the world, but there it is.
Well, I apologise again for my part in that earlier.
No. Well, it's the same. My part was much worse early on, but we couldn't work out what was going on, even with the assistance of the IT man, Ajaz in Dubai. He was doing his utmost to talk me through it, and nothing seemed to work. Anyway, apologies for that, but thank you both very much.
No, not at all.
Unless anything else that anybody needs me to deal with, and I look to May to tell me, I shall sign off.
Thank you very much. Nothing from me.
Thank you very much. Appreciate it.
No one's saying nothing. I'll sign off. Thank you very much.
See you all.
Bye, everyone.